Right.
Page mentioned.
To the page mentioning.
Supplemental list. Page number 1, item number 1 to 5. Page number 2, item number 6 to 14.
Pardon, my lord. Item 3, my lord. The second copy is not supplied, so I may permitted one with time to some. Item 3, my lord. You are Mr. Roth, my lord.
You are Mr. Roth?
Or Mr. No, I am Mr. Behra. Say that the request of Mr. P. Behra, counsel appearing for this petition, let the matter be listed on 11th of September 2020. In the meanwhile, the defects is identified by the registry shall be removed. File the second copy, that is the defect identified. Okay.
Page 2, item 6 to 14. Page number 3, item 15 to 20.
Item number 20 was supposed to come on 5th of September because batch of that is having fixed to 5th of September. So it will go to 5th of September.
Yes.
Mr. B.S. Tripathi on counsel appearing to the respondent has pointed out that analogous petitions appeals are posted on 5th September 2023. Let this appeal also be listed on 5th September 2023 with the analogous appeals. You just inform Mr. Behra.
No, Mr. Behra is here.
Any
Where is he?
order? No.
I've told you just now he was there.
Let me just inform him.
Is there any interim order?
No, interim order, in the first case, interim order is there.
Because
There is interim order.
then ask for it.
Interim order is passed earliest, shall continue till the next day. Mr. P. Behra, standing counsel transport appears for the appellate. It will come there. He says the analogous appeals are listed on 5th of September. That is why you have shifting and also 5th of September.
Copy of the. Copy of the. No.
Just supply a copy of this. Yes.
Page 4, item 21 to 25. Page 5, item 26.
Yes.
Sorry.
Just a minute. There is a problem, Mr. Behra. In which interim application this stay order has been passed? Can you just ascertain?
Not looking
The interim order was passed, my lord, in the leading case. In the leading case, my lord, interim order was passed.
Okay. You just tell the interim order if it shall continue. All right.
There is an idea.
That's all right.
2020.
He says there is no interim order. Interim order was passed in the leading case.
But the judgment, blood, common judgment has
All right, one order passed is state for all.
There's 1633 in the
Page 9, item 27 to 29. Page 10, item 30 to 35.
Item number 34.
Yes.
On behalf of Mr. Das, my lord, he is suffering from high fever and cold. So may I pray next week any day?
Next week will be very difficult.
Any other
Close date, any close date will be tried.
man?
Give a date.
11 September.
It will come on 11th September.
Man.
My lord, item 30.
Item 35.
34.
Item number 34.
Okay.
My lord, item 30, I'm appearing to
Just inform Mr. Sanatan Das, counsel appearing to the appellate, let the matter be listed on 11th September 2023. Item?
I'm into it.
My lord, I'm appearing through VC, my lord. My lord, item 30. My lord, item 30, your lordship. My lord, this is an appeal, my lord, wherein the learned single judge has treated a licensee with equivalent to a lesser and accordingly dismissed an application wherein the BTA has taken over the property. My lord, now as it stands today, the property has been demolished and I'm claiming for compensation in terms of the lease deed that has happened, which the learned single judge has refused to grant me in the writ application. Your lordship can fix this matter on any date at a convenient time. It can be disposed of, your lordship.
Not 5th of September, it will come on 11th of September. But Mr. Saurav, I think one thing, this is completely a matter of the nature of civil dispute. You are supposed to approach civil court.
That is
Because
right, Your Lordship.
if it is out of any agreement, reason is virtually in principle is an agreement.
Indeed, Your
So
Lordship, my
whatever
lord.
is done under section 74, you have to quantify the damage and evidence is required to be recorded by any court.
My lord,
Therefore, you take the liberty from this court, take the liberty for the approach and we can
the
observe
learned
that.
single judge has directed also. The learned single judge has directed me to approach the civil court for compensation and computation. However, my lord, my claim is this, that the lease deed says that I am to be entitled and to be given an equivalent space at a property. My lord, now a new place is coming up wherein, my lord, I must have the right.
All right. Look into this matter. It will be coming on 11th of September.
I'm grateful, Your Lordship.
At the
My lord,
request.
can we have it on 12th, my lord?
Huh?
Can we have it on 12th, Your Lordship?
12th September? Yes, can be.
I'm grateful, Your Lordship.
Mr. S. Showed Learning Council appeared to the appellant. Let the matter be listed on 12th September 2020. You inform Mr.
I
Mahapatra.
will inform Mr. Mahapatra, Your Lordship.
All right. Because I always insisting all the members of the
Yes, my
bar
lord.
that they should inform the council for the other side before they mention the matter before the bench.
Your Lordship, my lord. I will do that, Your Lordship. I'm sorry.
All right.
Page 11, item 36 to 40. Page 12, item 41.
Item 41. Regarding promotion to the post of assistant. Yesterday, my lord directed me to file the affidavit. Today, I am filing the affidavit.
That's the matter we called out. You file it. Because the council for the other side.
Yes, he is there.
Who is there?
No, I'm on behalf of Mr. Mohanty.
Okay.
Yesterday, lawsuit said to that the order will be reserved.
Now we'll be reserving the order.
And today, in course of the day, we are also filing the short notes or some.
Please let you file it earlier. You close this matter. Afterwards, we will not take anything because it creates a lot of problem.
Only will file the note of some.
File will be closed.
You file and mention at any time.
Nice.
Yes. All right. Call the next my advice. You take on record.
Page 14, item 42 to 46. Page 15, item 47 to 50.
I'm appearing for the
Page 16, item 51 to 55. Page 17, item 56 and 57. Page 26, item 58 to 61. Page number 27, item 62 to 66. Page 28, item 67 to 70. Page 29, item 71 to 75. Page 30, item 76 to 79. Page number 31, item 80 to 83. Page 32, item 84 to 87. Page 33, item 88 to 92.
Item 88, my lord, the cover matter may be taken up after lawsuit.
No, it's not covered now.
No, this is not a cover. Similar judgment is passed by them.
No. Please give me the.
Supposing that let the matter come. Okay.
My lord, on my mention, it was listed. Let the matter to tell tomorrow, today or tomorrow. Since last 4 years, may retired employee.
May I say, my lord?
The matter relating to the
Let's take up this matter on 5th at 2 p.m. so that matter can be disposed of. But he's saying that it's not a covered matter.
Like cover matter, I am satisfied, my lord. The two decisions I have.
Oh, it is there. Huh?
Two decisions I have, my lord.
So let it be on 2 p.m. Let it be 2 p.m. September. Is this matter? September 2023 at 2 p.m.
May I pray, my lord? Let him supply the copies of the judgment what he is relying so that I can verify those documents.
Today also, with the death check.
No, not necessarily.
Supply the copies of the judgment. Yes.
Page 34, item 93 to 98.
My lords, I have 93 dollars. I'm appealing for the Orissa Association of Blinds If your lordship could fix a date and time, my lord, it could be.
Why? The exchange of affidavit is complete.
Yes, my lord.
We have filed the counter affidavit
And the rejoinder also.
When the matter can be taken up?
last week of September or third week of
12th of September in fixing the matter, huh?
Right.
But time, my lord.
No time, don't insist for the time. On that day you mentioned that we'll face the time. The request of MS Middle Party and Council according to the petition and that the matter be listed on 12th September 2023. Mr. D.K. Mohanty and additional government advocate is appeared for the state opposite parties.
Item page 35, item 99 to 102.
Item 102, lordship. I am for the private opposite party, the lordship. Last week, the lordship had the matter admitted and stay order was granted. This is to today for final disposal, lordship. 102 minutes to be reached, lordship. I pray after lunch, lordship will take up. This is a my unit, lordship. The commercial unit has been closed since 2007, lordship.
It take much time, so you better go for another date.
So, last week, I have also mentioned, lordship.
The first will be accommodated. Let's see what we can do. 29, there are other matters set to.
Since 2029.
29th at 2, we are fixing your time and date also. 29th August.
29th this month. Obliged.
This matter will be listed on 29th August at 2 p.m. for disposal on merit. You, Mr. You just informed me.
Yes, I have already informed. Now I will inform you regarding
this at the request of the staff is the line. Mr. S.K. Borrell and also appearing for the opposite parties. Sorry, respondents. Let the matter state. Mr. Borrell and council shall inform Mr. B.S. Panigrel and council appearing with the appellant. Yes. Shall inform.
grateful alerts.
I may pardon your lordship. I'm mentioning one item, WBC 2788 of 2023. The matter pertains to appointment of the Cardiac Odisha Medical Education Service, lordship. This matter was listed yesterday before Honorable Justice Savitri on Mahapatra's court. Cardiac Odisha Party opened 4 reason objection regarding the assignment, your lordship. In this matter, it is a fresh admission matter, and this matter we are not claiming any right against any particular educational institution. It is a service cardiac matter. It's a cardiac matter.
Are you challenging any rule or any provision?
No. Challenging the application on the ground of application, and there is one post lordship, only one post available, and we can appointment. I pay lordship to list it to the lordship. This is a very urgent matter.
Why it will come to the division bench?
No, I yesterday mentioned Justice Aditya Mahapatra said that this matter is directly to list this matter to before the appropriate bench. But the matter
The appropriate bench.
I understand. And
Go to the register judicial.
I seek your lordship just to release this matter to you.
Because in the judicial order I cannot pass. Try to understand this.
I understand.
You go to the register judicial. If the situation so demands, you bring the matter on the administrative side and I'll pass order. You go right now there.
And for taking up on the same day, you have to mention before that bench. So you find out also.
Your lordship, this matter listed yesterday.
No, we have understood.
Yes,
But
Go to the register judicial. If there is no assigned bench, and because Justice Aditya Mahapatra has not recused, he has only says it is not the assigned bench.
No. He said that it is assigned to his bench or any other bench.
The Aditya Mahapatra has not recused.
Yes, your lordship.
He has a doubt in his mind whether he has the assignment or not. We will clear it. Go to the register judicial. He will clear it and will list. Tell me that I have told him to list the matter at 2 before the assigned bench. All right. I don't understand.
This is compounds appointment matter. compassionate
So
appointment.
single judge has rejected your application. So has dismissed. Review.
Review petition on the basis of what?
Because this appeal is pending, that is not decided, that's what I will come to this.
Appeal is pending in respect of whom? About you.
Huh?
Your appeal is pending.
So then why did you, no, was your plan to dispose of the appeal
Yes.
or it is for appointment?
No, appointment
Check up. Then give the list, we'll check up.
Pardon to make mention, my lords. My lords may recall, there's a forest for public interest litigation, but my lords have passed an order, certain compliances within 15 days, filed an application seeking urgent clarification regarding the order. Will be taken up on Monday, subject to my
What
lords.
clarification?
Well, it's regarding the compliances to be done regarding the, what's the extent of forest land, as well as we have filed an additional.
Wasn't the order clear that encroach forest land? That we have specified, I
Well, it's,
think.
we need some, because during the
So you need clarification or you need time?
We will not accept because we think the order is very clear.
Well, it's also like, we have filed an implement
No, no.
application, we have a resolution
We
application
not-
where certain
Will not-
additional
will
protections are
not-
given under the IBC, my lords.
You
to
find
take-
there is no urgency in explaining the thing.
To be taken up on Monday, my lords.
No, we are not passing any order. You file.
No, pardon.
Because you clearly said the machineries and other things from the enclosed land should be removed
Well,
within
it's
15
already
days.
the recommendation has been given for regulation, which is permitted under the MOF guidelines also, my lords, and there is statutory protection under the IBC.
That could have argued at the point of time. You did not. Your counsel was there. And we have taken consideration of all these matters, that there is a process because a recommendation. Someone applies for the recommendation doesn't mean that he'll be allowed to continue in the forest land.
My lords, there is a scheme for exposed factor and Supreme Court
No, that-
cases where a corporate debtor, like, where a company has come through the insolvency process, new management, they have said like special protection should be given to those assets, my lord.
Not to the illegal occupation of the
Even
forest
if
land.
there, I will show the relevant judgments, my lords. May
No,
kindly.
we will not open up
On
this
that
order.
page.
Okay,
That way.
please.
Beg to pardon, my lord, this is a fresh review application, my lord. My lord, in this, the writ application was dismissed before this honorable court, my lord, in division bench, my lord. That the petitioner,
Division bench.
my lord, before your lordships, my lord, previous division bench.
Final application.
For review, my lord, only on the ground, my lord, that the petitioner filed an application directing to.
Review application. There is no urgency in taking up the review application.
No, my lord, there is no audience, but I have filed a.
It will be listed for us.
Lordship, the contempt arising out of this writ petition that I'm mentioning before your Lordship is assigned before Honorable Justice K.R. Mahapatra. During the course of hearing, the learned counsel for the petitioner of the contempt petition has pointed out that IF a recall of this writ petition has not been assigned. Hence, an order has been passed to place it before your Lordship for appropriate assignment.
All that will decide in the administrative side.
The judicial.
Go to the registered judicial.
My lord, fresh writ petition. The present appellant is the petitioner before writ petition, challenging the order of memorandum of charges on the ground of vague charges and not specific. The counter resumed the written note submission file, and where the honorable single judge dispose of this, directing the petitioner to appellant to approach the authority. Now the authority, I am challenging said order, it is urgent matter. Taken up Monday, my lord.
Now the authority has rejected.
No, my lord.
So
The memorandum charges issued by authority, I challenge the said order. Memorandum charges on the ground of vague charges.
and what is the order of the learned single judge?
The directing the file so goes before the authority.
So
I challenge the said order before
why,
your
on the
lordship.
ground of, why you are challenging this?
Because that charges are vague and not specific.
Have you raised this objection?
Yes,
to the
ma'am.
disciplinary authority? Have you raised this objection before the disciplinary authority?
No.
So how can you come to the court, say that the charges are vague? It's not sustainable.
Shopper, you said that.
Not been taken up.
You have given the opportunity now. File your representation against the charge sheet.
No, my lord. I am directly challenging the memorandum of charges on the ground of the
In the memorandum of charges, there is no opportunity for you to file the representation.
Yes, yes.
Written statement of defense.
Yes, yes.
Have you filed it?
No, my lord.
Why?
I am challenging memorandum of charges, my lord.
Why you don't file the written statement of objection that this proceeding is not mentionable and then come to the court? But counsel, perhaps you are following a wrong process.
What you are saying here, say that in your show cause. If they don't listen, then you can come. Straight away, don't come.
You have been given the opportunity, written statement of defense, that you can raise all sorts of defense. Raise there first. If they decide not deciding in your favor, then you come to the court.
The matter of year 2012, my lord.
Whatever, that you have not done it, you don't have any right to challenge it right now. Sorry, that court cannot extend this jurisdiction and appreciating whether the charge materials is there or not.
Other two restoration.
All right.
With your lordship's permission.
May I mention a matter, my lords? This had come up before my lords on Friday. This pertains to the Orissa State Cooperative Bank, the appointment of the managing director. There's been a challenge, there's been an interim order. Now the bank doesn't want to defend that appointment and wants to move on and appoint a new managing director. Now, my lords, this matter is now being posted to 18th of September. We are under a court-ordered mandate to appoint the managing director by the 18th of September. Now, in this pending matter, my lords had passed an order, an earlier interim order, where the registrar of societies is in charge of the bank. Now, we have an elected managing committee. That managing committee needs to be given charge, and only then can a new managing director be appointed. So, my lords, if my lords can list this matter next week, it's something.
Have you filed any affidavit?
Yes, we filed an application specifically. We served the other side. I informed all of them today itself.
Right.
Next week, anytime.
Tuesday.
29th August. Obliged.
Yeah. With your lordship's permission, may I mention a matter? Lords, I am appearing on VC, my lords.
Yes.
Lords, this is the same matter where Mr. Mahapatra just mentioned. With your lordship's permission, this is the forest encroachment matter. Lords, we have moved two applications. Mr. Mahapatra appears, my lords, for the company, which is in Bharat. I appear, my lord, on behalf of the resolution applicant, lords, which is JSW Steel. Lords, we are seeking, my lords, impediment in the matter, lords, because we as the resolution applicant, my lords, under the provisions of the IBC, there are certain independent rights under section 31 and under section 32 of the IBC. My respectful submission is the lordship will kindly list this application. I quite see, laws, what fell from your lordships regarding the nature of the order that was
whether that petition survived or it is finally disposed of.
No, surviving.
Application will be
We have already filed, my lords. We are just
already.
May I request, my lord, that
we'll take up the matter. You file the application. If you not file it. All right.
Lords, that application has been filed. I am only requesting your lordship to kindly list it.
All right.
On a convenient date, perhaps.
The date is fixed probably. What is the next date?
next date is 4th September.
4th September.
So the list on 4th September. All right.
Lords, that application actually has been moved along with, my lords, an application for clarification and directions.
All right.
Since, my lord,
4th
your
September will
lordship-
take up the matter. Yes.
I may be pardoned to mention, my lord. One rate petition, your
No, it's already fixed on 4th September. Yes.
in one rate petition, your lordship has directed the chief engineer to appear personally in court yesterday. I am sorry, tomorrow. I am very sorry. I only pray that there should be a noting entry that it will be taken, because after launch,
You mentioned tomorrow.
if there is otherwise, the other side lawyer will not be in a position to.
You inform other side lawyer what I am telling you. It will be taken in the first round.
Yes, at 12 noon, if
This is at 12 p.m. No? That matter. What is the?
that is, yes, I am giving the memo. Only if there is a noting, then the other side lawyer will also.
Since there is a personal appearance, you can take up the matter early.
But you inform them. Inform the other
I
party.
will inform, but if there is a noting, then naturally they will.
All right.
Now that noting you have to show to them.
No, she is a very sincere.
No. If you show the noting, then they'll know that it is there, because earlier the direction was not there.
Supplementary stress admission item number 1.
File application for implementing OP number 7 is the party mail last time directed to add him, or he is now selected the annulled worker after fresh advertisement.
What is your application? All right. File number 536 of 2023. Mr. Pundia, I think implement can be allowed.
Yes, ma'am.
But Mr. S.K. Das and Councillor came to the applicant. And also Mr. M.K. Pundia and the National Government Advocate. Appearing to the state opposite parties. This is an application for implement of one Sunita Raut, wife of Chapradhar Bheed of village Balrampur, post office Balrampur, Kaladar, place Janapur, district Jajpur, as respondent number 7. It has been stated in this application that if the WA, if the interport appeal is allowed, the respondent number 7 may be affected prejudicially. Therefore, our implement is essential. Mr. Kuntial and additional government doesn't oppose the prayer for implement. So we also do not find any impediment to allow this prayer for implement. Accordingly, this application stands allowed and disposed of. The Sunita Raut descriptions of who has been provided above be ingredient as respondent number 7. The list is directed to incorporate the name of Sunita Raut with the descriptions as respondent number 7. So, accordingly, this petition is disposed of. Next in main WA. In view of the order passed today in IA number 568 of 2023, we issue notice to newly added respondent number 7. Issue notice and newly added respondent number 7. Huh? The notice is made returnable. Is there any date in this matter? No.
The notice has not been issued yet.
6 and 7
also.
Others notice has not been issued.
But 6 and 7, both persons.
No, 1 to 5 you are accepting.
I'm accepting. So
Let us see what is your challenge.
When I am challenging the selection of annulled worker, my lord, I am a super highest mark, my lord. Regarding me, they selected the open number 6, my lord.
But there is another ground because of perhaps residence.
No, my lord, what happened? I approved this report. And as per direction of this report, I filed an appeal, my lord. During the appeal, they selected illegal that open number 6. And during the appeal, that he was resigned from the service, my lord.
Okay.
My appeal is due to that appeal, my lord. Hence, the file fresh attended process sorts that fill up the post, my lord. And during advertisement, I approved this report and also annexer 3 the fact that advertisement. And as for that advertisement, the open 7 is now selected, my lord.
It is a fresh cause. This is a completely a fresh cause.
Because it is challenging the first.
No, how can you continue this challenge? Because your challenge is fundamentally against 6. Now 6 is no more there. They have appointment respondent number 7. You file a fresh petition. Because maybe the ground may be the same because it is a fresh petition. It's new recruitment process, new appointment. So you don't press this writ appeal, and we will allow you to raise all these grounds you have taken in the earlier writ petition. All right, I think that will be better. Mr. Will then the score out the also I also.
Because the second one I am not an applicant, my lord. The first one I am applicant. The second I am not applicant, my lord.
So
Because if I was
second one, whether the respondent number 7 was participating in the
yes,
selection
yes,
process?
yes, because
Yes,
I
Surendra.
substitute first one, then there is also some advertisement second time, my lord.
Then the first one they become infructuous because the 6 has not selected again and he has resigned because he was found not eligible for the appointment. You decide what you will do.
I will one urgent request.
Just go out. Unless the matter be listed on 12th of September. At the request of Mr. S.K. Das, Current Council appearing for the petition. Mr. M.K. Kuntiel and additional government advocate has appeared on advance notice. The best recourse would be just you ask to leave to raise all the grounds in the fresh writ petition. Otherwise, it will be only complicated things. I always follow this line. Yes.
Item number 2.
Item number 2, my lord, there is some defect, my lord. I have taken the next. In the meantime, the defect shall be removed.
All right. You are Mr. Anirudh Das.
My lord, S.C. Mishra.
At the request of Mr. S.C. Mishra and council appearing for the writ petitioner, let the matter be listed on 21st, 22nd, 21st, 21st September. 26th of September 2023. In the meanwhile, the defects identified with the registry shall be removed. No further accommodation for the same purpose. Next.
Item number 4. No, please, let's see. My lord, last occasion I directed to take instruction. This relates to that a professor.
Yes, Mr. Behra.
Well, I've just received instructions. There is a master resolution dated 25/4/2022. These are the guidelines for engagement of assistant professor, associate professor, and professor in government medical colleges.
But he's a professor.
This is for professor also. And clause 9, subclause 1 says the engagement shall be purely temporary and on year-to-year tenure
seeking regularization, because we are asking you the very clear that till the regular appointments are made, whether he will be allowed to continue as this professor.
My lord, the circular says that the maximum period of 4 years is the tenure.
Annexure A explains that.
4 years.
Annexure A that has been kept in the evidence. Annexure A, that is Parag, the authority is not with this knowledge. Annexure 8 may kindly have a glance valid.
Well, may I request your lordship may keep this to next Friday. By then I will have filed my counter affidavit. 1 week I'm requesting.
My lord, on similar issues, 6 writ petitions are filed and they have been protected. Let him file a counter, but
no, you also allow him to continue.
My lord.
Well, I'm seeking 1 week time because no prejudice will be caused to the petitioner in 1 week.
May I place one thing, my lord. This is the petitioner who was continuing the post of professor. He has worked for more than 40 years in the institution. He retired in 19. No one is ready to join there. The post is lying vacant. Adjust get the work done. He's continuing there. Now also the post is lying vacant. And
no, he's seeking one who stay the next Thursday, the matter will be taken up. Let us decide. Because already you are out of the engagement.
May one thing,
30th August, 31st August 2023.
He relying on the
all right, let him file, you'll check up also. At the request of Mr. Rana Behra and the request of the additional standing council. Meanwhile, the state opposite parties shall file their affidavit. Stuff. Copy of the affidavit shall invariably served on the council for the appellant on 30th of August 2023. Stuff. Mr. A. Mishra and council has appeared for the next.
Item number 5, 31st, man.
It will be 31st, but I have directed to supply the copy of the affidavit on 30th.
May I pray, my lord? My lord may say that if the post is still lying.
Because you are already vacated, you are not there. That is why I have not passed as interim order.
My lord.
May I please yours?
Item 5.
At the outset, I have submitted the certified copy. Yesterday, I have got it, you have filed the certificate.
So there is an application.
Application for dispensing the certified copy.
Where is that? Yes, that will allow and dispense it.
Yes.
Otherwise, you will file another interlocutory application for condonation of delay.
No, there is no delay.
There is no delay.
No.
How can you say that?
That's okay. But I'll take it up.
File the certified copy yesterday.
Yes.
Not yesterday, now.
But the order was not pending.
Then?
Till 18.
Oh, all right. All right.
I've checked on that.
As the certified copy has been filed, 5621, within time, this application has become infractions and according to the same terms disposed of.
Now, can we come to page 182, the order of the Honorable Single Judge? It's a case of appointment of Honorable Worker, where I am still continuing.
Yes.
And the page 182, the Honorable Single Judge has neither gone into the affidavit filed by the state or my affidavit.
All right.
Also,
what you have decided?
Yes, said that based on the Paravez comment which was filed in the appeal filed by the petitioner, the petition, a portion of the Paravez comment just picked up and.
Mr. Behra, we are admitting this appeal. And we fixed this matter to be heard on 12th of September.
Your Lordship, notice has to be issued to the private respondent.
No, that we are issuing notice. There is a speed post that will be issued.
Admitted fact is that the appellant is on government encroached land. That is admitted in the.
Mr. Behra, I have not seen the affidavit filed by the state.
Don't exchange the words. Address us.
Supported by two judgments.
As Sushant Kumar Mishra, Lord Counsel, preparing for the appellant. Stop. BS. On your file.
Yes.
Mr. BS Tripathi.
Admitted in the written.
Sure. By means of this intercourt appeal, the order dated 10th August 2023 was by the Learned Single Judge in WPC number 19017 of 2016 has been challenged on the ground that certain materials have been taken into consideration which are not part of the pleading. Stop. With it as it may, we think this is a case where this appeal should be admitted. Admit, issue notice. Since Mr. A. Behra, and standing counsel, appears and accept notice for 1 to 4, respondents number 1 to 4. No formal notice is called for in respect of those respondents, but Mr. Tripathi Learned Counsel shall furnish one additional copy, or don't need. You have you are scanned your copies, no?
Yeah, Lordship, we don't need extra copies.
All right. Stop. But the appellant shall take steps for service of notice on the respondent of 5 by speed post with AD in the course of the day. So notice is made returnable on 12th September 2023. There shall be an attempt to hear the matter on merit on that day. All right.
That order of the Honorable Single Judge, the state,
what is the
I am continuing. That is it.
Whether by this order you will not be discontinued. All right. Status quo in respect to the engagement of the appellant shall be maintained till the next date. Yes.
Item number 6.
The service of copy by tomorrow.
By tomorrow, I told you ask a speed post.
Speed post by tomorrow.
Tomorrow, next day, tomorrow. All right.
Urgent copy of that.
Urgent copy of the order.
Item number 6.
May I please, Your Lordship?
I'm appearing for State Information Commission. The time is required to file counter. Lordship kindly give us time so that.
You want to file a counter?
Yes.
All right.
My lord, as per the last order, the counter is supposed to be filed today.
There are so many defects are there also in the reproduction. Can you remove it?
So, all right.
My lord, may kindly see the para
Four defects are there. Remove the defect first. These are very omnibus allegations. Very allegations are not.
We give a shorter time,
Yes,
but yeah, they have to get the opportunity for filing
Yes,
the
ma'am.
counter affidavit.
All right, my lord.
Fix the matter on 12th of September. In the meanwhile, Mr. Das will arrange to file the counter affidavit, right? And you also remove the defects.
Yes, four defects are there.
Can we request of Mr. D.K. Das, Land Council, for the State Information Commission, and the matter will be listed on 12th September 2023. In the meanwhile, invariably, the State Information Commission responding shall file their counter affidavit. Yes, this court proposed to take up the matter for disposal on merit on the day. Mr. Amit Kumar Das has appeared in person. You are Dr. Amit Kumar Das.
My lord, that is PhD. Doctorate. So it is only Amit Kumar Das is okay.
All right, Amit Kumar Das has appeared in person. Mr. Das is directed to remove the defects as identified with the registry within 7 days from today. In this, you can see the note. There is some defects have been identified. You come and remove those defects. All right.
All right, my lord.
Item number 7.
May I lordship, please? My lord, I'm in the VC, my lord.
Yes.
My lord, this is a PIL, my lord, being filed
Yes.
by the petitioner, my lord, in the interest of the larger community involved, my lord, in the process of a clay idol making and the Hindu culture involved in this matter, my lord, the deep-rooted Orissan culture for the preparation of clay idols, particularly, my lord, Lord Ganesh, Ma Durga, and Ma Kali. My lord, the petitioner challenges the inaction of the respondents, my lord, in particularly not digitizing the film of Matira Vandhan, my lord. This was, my lord, required to be instructed, my lord, due to the modern technology to be involved in this matter, my lord. Nowadays, my lord, digitization is continuing in each and every sector, my lord. My lord, this Matira Vandana was a eminent, was written by and directed by the eminent director, my lord, Himanshu Shekhar Khatwala. And my lord, this is details, my lord, kindly comes to page 5, my lord.
No, we do not know how this matter can be a public interest litigation.
Yes, my lord. Yes, I am coming.
Regarding this digital format of a film, old film.
I think the petitioner himself was the hero of that film. He himself is the hero of that film.
My lord, Mihir Das, the eminent Odia.
We understand, but how can the court can
in a PIL, you can have
the government must have a policy first that which film will be digitized, which film will not be digitized.
Why I am saying, my lord? Why I am saying, my lord?
We understand your anxiety. Council is just appreciate us also. So far the digitization of any old film is concerned, it depends on the government policy.
My lord, the point is that
what is according to you required to be digitized may not be according to the government that film should be digitized.
My lord, why I am saying, my lord?
What you ask you that you have not, your representation is there. We ask them to take action on the representation within a period of 2 months from today.
Yes,
in terms of the new film policy as declared by the state government.
Yes, my lord. Yes, my lord. Yes.
That's all.
My lord, if my lord permits, can I pray another thing, my lord?
Yes.
My lord, if you, my lord, come to page 6, my lord, I have categorically mentioned in 4.10, the film was made on celluloid base, after which the analog process of shooting become obsolete. There is no preservation process for such print at the place of Swanshu. It is pertinent to mention, my lord, if the print would not be preserved in proper condition, can catch moisture, fungus, and emulsion.
We know how the films get damaged. We know all these things. But the problem is, can the court direct for a particular fee to be decided? We can ask the government to consider your
My
representation.
lord, another important point your lordship may see, para 4.6 at page 5 of the writ petition. This film was never publicized.
My lord, this is released. This is a short picture, my lord, short film. This was, my lord, in Bombay Mahotsava, in Bangalore International Film Festival. This was, my lord.
No, you yourself has avowed that it is never released because the producer was
That is what I am saying. My senior is right, my lord. I am coming to his point, my lord. My lord rightly said, my lord, this was seized because, my lord, my lord rightly said.
And all these things are seized by the CBI.
Yes, no, the EOW, why, my lord?
Anyway, by police agency.
Yes, my lord. But the point is that, my lord, this is the culture is involved. The Odia culture.
All right, we got your point. Just wait.
I'm grateful, man.
But Mr. Sanjeet, you are Mr.
Vibhuti Bhushan Chaudhary.
Mr. Vibhuti Bhushan Chaudhary, when counsel appearing for the petitioner by means of this public interest litigation, petitioner has asked this court to direct the state opposite parties to take urgent steps for digitization of the film titled Mati Ero Bandhana in italics for its preservation, as the said film is a part of the heritage of Orissa. So in this regard, the petitioner has filed one representation on 22nd May 2023 to the Chief Secretary of the Government of Orissa. But according to the petitioner, no action has been taken thereupon. Mr. Chaudhary, Student Council, has brought our attention to a newspaper clipping connection to this petition, whereby the state cabinet has taken a policy that they will promote Oriya films, facilitate film tourism, establish Odisha as a destination of film shooting, and improve screen density in the state. Stop. The said policy in any manner doesn't cover the prayer of the petitioners. However, we would direct the state opposite parties.
May I pray one thing?
I'm not directing, just a representation.
That representation. The Lordship may direct the PR department, not the Chief Secretary. Opposite party number 2 is the PR department.
All right,
yes, that's
the opposite party number 2 to consider of adopting a policy regarding preservation of the important Oriya films produced in the earlier days and have had critically acclaimed stuff. With this direction, we dispose of this petition. Stop.
Free copy of the order.
A free copy of the order we supplied to Mr. Mohanty, D.K. Mohanty, and Council has appeared for the additional government advocate who has appeared for the state opposite parties. So we have asked them to consider for adoption of the policy. We want in policy, they will go by the merit. Yes.
This order is sufficient for it.
Item number 8.
Oblige, my lord.
Yes.
Not in this case, earlier occasion, the writ was filed as per the PL
in WPC number 11601 up to 2023. On earlier occasion, the Lordship was directed to file a fresh representation for the concerned authority. Thereafter, on filing,
And Council, there is a provision for de-reserving the Gochol land for the public.
Yes, that is there.
There. You want a blanket restriction. Would it serve the public interest? Suppose a road is being constructed.
yes, ma'am.
Only the government can take a decision of the comparative public interest. The road is essential or keeping the land vacant is essential.
Yes, my lord. But there
You are
is,
coming for a blanket restriction against the government.
but there is some
My lord,
other rules there, my
With
lord.
one thing, all these PILs are due to political rivalry. Some people
No.
have this road go this way, others people, the other group of people, they want that road should not go in this way.
That's all right.
So this is an outcome of all these
This is not the political rivalries, my lord. My lord, this is the communal purpose is to have the watcher land there, grazing the cattle and the one still is, my lord.
I'm not just making this comment or corresponding to you, whatever you are on merit you have submitted in the petition. Who are in a better position to decide how the road will be constructed? Ordinary citizen or the expert department set up by the government? Who are in a better position? Tell us. Or the court?
The government,
Government department. They have taken decision. If you have any grievance, take the grievance to them.
yes, my lord, already grievances are there.
That the grievance I am saying not about Gochol.
But in fact,
No, that is the Gochol land. I am telling you that let the government also decide whether the Gochol land should be reserved for purpose of construction of a public road or not. If
No.
only grievance is not over the Gochol land,
in this regard, a representation was filed before the collector.
that we got the point. I am telling that what you are
Yes, my lord.
submitting, it will create only the situation which will go against the public interest.
Yes, my lord. In this regard, I am filing a representation before the collector, concerned authority collector. But no effect has
Already we will
Come on.
asking the collector to dispose of your
The
representation.
representation is to the sub-collector, right?
no collector and sub-collector.
Page 23, annexed 5. Singito Upajillapala, Anandpur.
No, that is not.
Then
No.
which one?
Reminder,
A representation dated,
Page 31.
page 31.
I think
Right answer 8, my lord.
8.
Right answer 8, my lord.
Page कितने?
Yes.
Actually, 8 is page 29.
29.
What is your prayer? Read the last paragraph. Last paragraph of that representation.
My lord. Your lordship. ଜିଲ୍ଲାପାଳ କେନ୍ଦୁଝର ଖେଳପଡିଆ ଉପରେ ବେଆଇନ ରାସ୍ତା
Korea. So Gochor land, the allegation is that there is a playground.
using on a playground by the primary school students.
Then how Gochor land can be used as playground?
But PETA shows that, but the record shows that as it is Gochor land in Mauja Contamania.
All right.
My lord, that means this land lost its characteristics as a Gochoro. According to the petitioner, it is used as Khelapodia for.
No.
He has given the photographs also.
He has an evidence in his favor. Sri Krishna used to play in the Gochol land only. So there is a
Right. If your lordship is correct. But at that point of time, everywhere there is Gochor land. Because they were in a privileged position then.
I'm just asking
My lord.
that your concern is well, but the road is a very important thing for a village. For the development of the village. Don't stop this
The road has to be constructed. That is for the benefit
My
of
lord,
people.
if there is no other road, then to construct. But then also.
No. Even there is other road also. Another road is also helpful to the villages.
No, my lord.
Page 27, Rasta Nirman.
Destroying the,
It is just like that.
in this regard, some law and order situation was there.
All right.
That has to happen.
You are Mr. Das.
Yes, ma'am.
But Mr. Sanjit Kumar Das will counsel appeal to the petitioner. this petition under section 226 has been filed in the form of public interest litigation, urging this court to direct the opposite parties number 3, 4, and 5 to take effective steps from construction of the effective step preventing construction of the road over the plot number 206 and 428 recorded as Gochor and Basti Joggo land.
Basti Jogyo.
Basti Joggo land. Adjoining to Kanta Bania Primary School. Stop. It has been stated by Mr. Das and counsel that the petitioner has filed. Petitioners have filed one representation to the district collector on 25/4/2023 within bracket annexure 8 to this petition, urging the similar relief. But no action has been taken on the representation of the petition. Mr. D.K. Mohanty, learned additional government advocate, appeared for the state opposite parties, has submitted that construction of the public road over a village also protects the public interest. That apart the land is not entirely Gochor land, according to the petitioner. Stop. Even the land comes under the classification of Gochor, then also government has the right to reserve it for purpose of any project in the public interest. Stop. Therefore, the petitioner's prayer cannot serve any public interest. Stop. I think appreciate the submissions made by the council for the parties. We are of the view that the petitioner may have grievance so far the Gochor land is concerned, but we find the dominant public interest lies with the construction of the public road. As such, we decline to interfere with. We are not inclined to grant any relief as sought before us. Stop. In terms of the above, this petition stands dismissed.
Pardon, my lord. In this regard,
we have passed the order. Is it clear to you?
Yes.
All right.
Item 9.
If you insist, we just impose huge cost on you. We must stop also the frivolous litigation coming to this court. All right.
Item 9.
Last occasion, my lord, the this matter is making the last order. The order dated 18/8/2023. There, my lord, directed me to obtain instruction is how the fees for use of the groundwater has been imposed on the petitioner and how the penal interest has been imposed is for purported non-payment of the fee. And I have obtained the instruction that at present the petitioner is using the surface water.
Okay.
Surface water from Bodojoro Nala in Dhenkanal town.
So this is the issue actually primarily is that whether you have any notification even under Article 162 by imposing any fee for using this surface water.
The rule is there.
What is the rule?
Rule 23.
23 capital A.
Capital A.
Read 23 capital A, how it covers the surface water.
Very opening word, if you looks at, when any industrial, commercial, or other establishment proposes to draw or lift water from the government water source. The definition is there, government water source.
And that they also we have referred to the government water source. Does it the
6A.
6
Section 6. Subsection 6 small a.
Yes. Section 4, subsection 6A.
Government water source means any water source created naturally or otherwise by collection or deposit of water at a fixed place, any subsoil water or water in a state of running such as rivers, nalas, springs, streams and the like, which is other than an irrigation work and is the property of the government.
What is the category of source you are referring to? From where the petitioner is drawing up water?
This is a nala.
Sir, kindly let me explain that. With due respect to a friend's statement, but till 2017, I was using through borewell. I made an application as at their instance to get it from the Nala itself, which is a river water, part of the river stream. But that has been done from 17 till now. There is no penalty, nothing else. But their old dues, it is rolling over till today. What they're charging prior to 2017.
That is the issue. Exactly. That was the issue. I recall
from 17.
This surface water drawn from their own instrument. What is the surface water? The state can claim any.
It was my borewell.
In that respect, because notice has not been issued, I have not filed. My lord can see page 72. That is the application which was submitted by the petitioner. Yes, to the government. Page 72, Annexure 6 series. That is letter dated 5/1/2009.
Page 72.
Yes, my lord. Annexure 6 series.
Page 72 of this petition.
So it's a part of Annexure 6.
No, page 72 is I think this is a agreement.
Yes, Annexure 6 series.
You're right. It may be the Annexure 6 series.
No, page.
No, it is a 9 series.
9?
Annexure 6 series.
At page 72.
Annexure 6 series starts from page 54.
No, my lord. Writ petition has been amended. My lord, probably my lord.
It's a consolidated writ petition.
The original writ petition probably. My lord may take out the consolidated.
All right. That I don't know.
Where is the consolidated?
That has been scanned or not? That's there. Yes.
Page 72.
Yes. Is a part of Annexure 10.
No, Annexure 6. Page 72.
It starts page 72.
In the annexure, they have not changed or what?
But it is the same thing.
Letter dated 5/1/2009.
Say that you can look for.
That is an Annexure 6 series.
Yes.
5/1/2009.
Yes,
Annexure 6 series.
Yes, that is running page 72.
Here it is 54 or the
54 of the earlier.
No, that will not change. No, that is the problem. As per the index, they should have changed the page numbers.
Yes, madam.
What have you done this lecture?
Well, this is a subject, my lord, we can see execution of agreement for drawal of water from natural resources for industries. Dear sir, enclosed, please find here with the prescribed format duly filled in along with the following enclosure for your kind information with a request for a good office to kindly give us the permission for drawal of 145 KL per day for industrial use, water from the natural source, that is from the borewell for our industrial use. Well, this is the application of the petitioner. Now, next page is the form. The form which he submitted in accordance with the rule, which is now under challenge. Well, in 2009, he accepted the rule and he submitted the application. Then, page 74, well, he has described the source as borewell. And accordingly, this was taken into consideration. Now, my lord, we come to page 75.
What is there in page 75?
Page 75, that is letter dated 2012-2010 of the petitioner. After necessary approval by the government for drawal of water, now the petitioner submitted this draft agreement.
57.
Page 57 of the original brief.
All right.
2012-2010.
Yes.
Subject, draft agreement for supply of water for the purpose of industrial use. In inviting the reference on the above cited subject, it is to intimate you that we have obtained NOC for drawal of 145 KL per day of groundwater for our manufacturing unit. The location of our industry is under the said category on groundwater consideration as ascertained from Central Groundwater Authority, New Delhi, and it is not required to put forth again in the district level of evaluation committee further. Since NOC has already been obtained bearing number so and so, valid up to 17/2/2010 for a period of 5 years. As per the recent amendment of the Odisha irrigation rules, we are submitting the draft agreement in the prescribed form K for taking further necessary action at your end. Well, he is well aware about the amendment now, which is now sought to be under challenge. 2010, he submitted the draft format. The next page, page 76, that is the form K. And that is submitted as per rule 23A2. Page 58, top you can see. Original page 58. Top is form K, rule 23A2E and rule 26. Now, my lord, may come down to page. Page, original page is 70, consolidated page is 88. That is the agreement. Let's have page 70.
Yes.
This is, you also can see, this is form K under rule 23A2E and rule 20, agreement for supply of water for the purpose of industrial commercial use. This was executed on 9th day of May 2011. Now, my lord, will kindly see next page. That is page 71. Well, schedule is there. The quantity we have mentioned, the period of supply, and to which place it will be supplied, that is mentioned. Now, my lord, next page, page 72, clause 3. Clause relevant clause is subclause 3.
Whether this 2,11,004 was deposited by the petitioner?
Yes, accordingly he was allowed. Now, my lord, we can page 72, clause 3. The relevant clause is subclause 3 at page 73.
You have deposited all the charges.
Yes.
Sir, I am paying throughout till now. Sir, the question arises here.
The default, what you are saying is...
Yes, that is why I am placing this clause.
All right. This
page 73, subclause 3, Roman 3.
Sir, interestingly, I used to draw from the long ballot, 85 onwards ballot. 2009, for the first time, they directed me that even if you draw from the borehole, you have to do it, otherwise you will stop it. So we are compelled to file an application as per their statutory provision, because no other provision is there for application. They compelled us to file it under Form J, and file an application.
Yes, Mr. Mudali.
Page 73, subclause 3.
Yes.
Roman 3, the applicant shall not draw or lift water more than the quantity mentioned in the requisition or order and not exceeding the volume mentioned in the schedule except with the prior approval of the government. The executive engineer shall assess the fees to be charged as per the unit quantity of water drawn or allocated, whichever is higher. If drawal is more than the allocation, a penal rate at 6 times the rate specified in Schedule 2 and 3 shall be charged on the quantity of excess drawal in addition to the normal bill on allocated quantity. The excess drawal is permissible for a maximum period of 6 months, others are not relevant.
Yes.
Then clause 4. The permission granted shall not be deemed to exempt the applicant from liability for payment of water charges lawfully accessible at the rate as may be prescribed by government from time to time. So he is well aware of these two conditions, that he is liable to pay the water charge as well as the penalty if he draws over and above the permitted quantity.
Yes.
So he has never challenged that, but rather he has paid the amount.
It is a contingent provision that in the event of his drawal of the excess water.
Yes.
What is the proof in support of that statement?
Now we have from time to time we are raising the bill.
No, that, but whether on the basis of any study?
Yes, meter is installed. Next page.
According to the meter?
Yes. Next page, clause 4 is there.
No, what is this meter readings and other thing on the basis of you have decided?
That I will produce in that. The requirement you will also get page.
No, this is. Then you have those meter readings.
Yes, meter is installed in the campus of the petitioner. There we have to show.
You
will also kindly see page 74, clause 4. The applicant at his own cost shall install a flow meter or a suitable measuring device for measurement of water drawn or lifted by him from the government water source as per the procedure laid down in Rule 23AB. The executive engineer shall visit the location of drawal or lifting of water, verify the quantities of water drawn or lifted by the applicant, and ensure such control as may be necessary for administrating the drawal or lifting of water. Assessment of water rate shall be made as per the quantity of water drawn or allocated, whichever is higher. In case of any defect or non-functioning of the flow meter, the licensee shall bring the fact to the notice of the concerned executive forthwith and take appropriate steps to remove the defects in the meter or for replacement thereof within a period of 2 months. And in such cases, the fees shall be charged on the quantity of water allocated for the said period of 3 months or till the defect in the meter is removed or the meter is replaced, as the case may be, whichever is earlier. And where the licensee fails to bring the defect or non-functioning of the meter to the notice of the executive or fails to remove the defects in the meter or to replace the same, as the case may be, within the stipulated period, the agreement shall be liable to cancellation and thereafter the water supply shall be stopped. So a meter is installed.
But what is the water supply? You are not supplying water.
No, that is the government source.
No, you are not supplying water. No, they are extracting water from the groundwater reservoir.
Yes.
It is a natural source.
Natural source, and that is the government source, as defined in Rule 4, Section 4. Section 6. Sorry, Section 4, maybe.
Section 4.
Yes.
Section 4, subsection 6, capital A, small a.
That may be at page 15 of the book.
Yes, right. So one thing is that it is very clear the petitioner usual charges the petitioner have paid. Right. There is no dispute.
No dispute.
So when petitioner defaulted and how?
As it appears from the
last order, we reflected only take the instruction on that aspect of the matter.
Yes, I have received the instruction. They have supplied the areas.
No, not the areas. How the petitioner became defaulter?
But that instruction they have not supplied. They have only.
If petitioner is not defaulter, you cannot charge on him any panel interest also. Forget about the penalty.
Right.
How can you do? What law authorized you to do that?
Under the rule, it is provided penal interest.
No, penalty.
Provided there is failure.
But there is no apparent failure.
So that I have to obtain instruction. What is the failure since 2011?
That is why you have asked by the last order, you take the instruction.
They have supplied only a part.
Because they do not have any materials to support their action.
No, I will come back so far as that portion is concerned. I will file a detailed affidavit.
We are fixing again on 31st.
Yes.
All right. Part in part, release the matter on 31st of August 2023.
Already no coercive action, my lord.
No.
You're running industry.
All right.
Let him pay the admitted dues. But
in the meanwhile, the state opposing parties shall invariably file their counter affidavit as we shall conclude the hearing on the day, on the next date. Stop. Meanwhile, there shall be no coercive action against the petitioner. All right.
All right. I'll go on paying the regular bill. I'll go on paying the regular bill.
However, it is made clarified that the petitioner shall continue to pay the regular bill without any delay.
My lord, I'm paying it. In fact, I'm doing it.
All right.
Item number 10.
Please, your lordship, my lord. I am at BC Puri, my lord. My response submission, my lord. Please make a class to the annexer 5. This is being the second round litigation. In annexer 5, your lordship was pleased to dispose the.
Yes.
My lord.
Yes.
This is being the second round litigation, my lord.
All right. You are Mr. Panigrahi.
My lord.
All right. You are Mr. Panigrahi. Am I audible to you?
Yes, my lord, able.
All right. Yes. It is a second round of litigation. About what?
But for getting the compensation amount, my lord, your lordship was pleased to dispose of writ application filed annexer 5 to consider my representation by the opposite party number 1. However, filed annexer 6, my lord, my representation was dismissed by the opposite party number 1. So far the case is considered.
Dismissed means they have not granted you the compensation. Am I correct?
My lord.
All right. Now come on merit how this petition is second term maintainable.
So far the case is concerned, my lord, in nutshell, the Indian Ocean Corporation was installed pipeline project, my lord, from Paradip Somanathpur to West Bengal Haldia, my lord, where my land has been acquired by the opposite parties, my lord, but specifically opposite party number 1. Accordingly, annexer 1, running page 12, notice was issued, my lord, to the present petitioner, though his land was acquired to get compensation amount, notice was issued to the filed annexer 1, my lord. Then, my lord, election
acquisition of.
My lord, your lordship may see the reasoning given by the officer at page 25. He has sold the property to third party. Third party has received the compensation. That is by means of a registered sale deed.
At page 25?
Page 25 of the writ petition. Gone through the arrestee number so-and-so, in which the landowner, Sri Dolo Govinda Lenka, sold out area 64 different land in the name of Sridhar Mahapatra, Chittaranjana Mahapatra, son of so-and-so.
This is in this manuscript, no?
Yes, manuscript.
In the fourth manuscript, yes.
Since that date of purchase, Sri so-and-so were in possession of the land, the pipeline from so-and-so. Accordingly, the compensation was also paid to them.
So what? Do you still the owner of the land?
Submission, my lord. So far the case is concerned, my lord, Dolo Govinda as well as my lord Bholanatha are two twin brothers. The property stands recorded jointly. Dolo Govinda sold out his share, but Bholanatha has not sold out his share. Accordingly, Bholanatha is entitled to get the 50% compensation amount, my lord. And though Dolo Govinda sold out the share to the private persons, then the private person are entitled only to get 50%. But the present petitioner is also entitled to get 50% compensation amount because he has not sold any.
If you have completely transferred your land, including the possession, if you have sold out, just wait, if you have sold out the land to a third party and you are also not in possession, from which condition that you can get the compensation? Show us the legal provision. Show us the legal provision. Because as a former owner, you are entitled to the compensation.
My submission before Lordship is two brothers. One is the Dolo Govinda, another is the minority, Dolo Govinda and Bholanatho. I am the Bholanatho.
You come to the page 25, please. Page 25 of your petition.
Hello.
Yes.
My lord said, has not sold any share, my lord. Has not sold any land to anybody, my lord. Only his brother, Dolo Govinda, sold out, my lord.
So go to the civil court. He has not sold out your share also. Go to the civil court. How the public this litigation can be maintained here?
That sale deed, if it would have been annexed in the deed petition, we can verify, your lordship, that how the brothers sold the share of another. There may be a family partition amongst them. I just
don't know. This is civil dispute.
All these are civil disputes.
Already, these matters are not supposed to be adjudicated under the Article 226. We do not have the mechanism of recording evidence whether there was a family partition without any document.
Oh, my lord, there is no family partition, my lord.
Already, this is the matter. Even without document, the family land can be partitioned. You go all the thing to the, you go to the civil court. Because that really.
Please make a glance to the annexure 2, my lord. Please make a glance to the annexure 2, my lord. Annexure 2, my lord. Please make a glance to the annexure 2, my lord. R1.
No, it is land acquisition. No, this is not the land acquisition bench. But this is the fact. What one brother has sold the entire land, and what is the reason of behind that? That has to be verified from the recital of the sale deeds. If at all his share has been transferred by another brother by virtue of any partition or something like that, and he is disputing it, then it is a matter to be dealt with by the civil court, to be decided by the civil court. How a writ court can decide? Once the authority relied upon the sale deed and paid the compensation to the beneficiary of the buyers, purchasers.
You go to the civil court.
Yes, that is the best remedy.
No, I'm telling you, this court cannot adjudicate all this question of title here.
Because I am the 50% shareholder, my brother, if I have sold out entire share, applying fraud, my lord, for which I am not held responsible, my lord.
But that sale deed has to be set aside, my lord.
Yes.
That has to be set aside by a proper civil court.
Yes.
But I humbly submit, my lord, for sake of the interest of justice, the matter may be notice by sir, my lord.
Already I have heard you.
This may be sir, my lord, for sake of the interest of justice, my lord.
But Mr. What justice will be done by the civil court, not by the writ court.
My responsibility, my lord. Though fraud has been taken place by my brother, for which I am not held responsible.
It is a very it is a rudimentary thing. You try to understand us. Your brother fraudulently or with a right, we do not know anything. Your brother is not before us. He has sold out the entire land which has been acquired. And you are I understand you have not done it. Go to the civil court, say that to sell it was this illegal.
Mr. Panigrai, we are not saying that you have no case. We are saying in a writ petition we cannot decide. So you go to the appropriate forum. That we are directing.
But he has taken entire amount. I am facing much of
Yeah, you first established your title over the land and then claim. And claim from your brother, not from the government.
But
yes.
only
Not Mr. T. Panigrai, learned counsel appearing to the petitioner. Yes, this by means of this writ petition, the petitioner has challenged the order dated 28/3/2023 Annexure 6 to this petition. By the said order, the it is the order of the collector Jagat Singhpur or whom?
OP number 1, my lord.
OP number 1.
All right. By the said order, the director Paradeep Somnathpur Holdiya product pipeline project has been decided that one Dolo Govinda Lenka sold the entire acquired land much before the acquisition to one Sridho Mahapatra and son of Niranjan Mahapatra, son of Kanduri Mahapatra, from the western side of the joint property by the sale deed number 2725 dated 27/10/1992. But it is an admitted fact that the petitioner, namely Volanath Nanka, though was a co-personal of the said land, did not sign the said sale deed. It has been also stated in that order by opposite party number 1, the compensation for acquisition has been paid to those Dolo Govinda Lanka in full. So it says the petitioner cannot claim any amount. Stop. Mr. Panigrahi Learned Council has submitted that how the opposite party number 1 paid the damage only to the Dolo Govinda Lanka, or Dolo Govinda paid to the purchasers who purchased the acquired land from Dolo Govinda Lanka, the opposite party number 6. Stop. But it has not been contested by Mr. Panigrahi Learned Council that the land on the question was sold out by a registered sale deed. Stop. Therefore, the title was apparent in favor of the purchasers opposite parties number 3 and 4. And as such, the opposite party number 1 has paid the compensation to them. Unless the issue of title over the said land is restored in favor of the petitioner, it is not expected from the opposite party number 1 to pay any compensations to him. So, it may be so the entire transaction was completely unauthorized and illegal. But the fact of whether the joint property was partitioned by a proper instrument or by family arrangement is a matter of fact which only can be inquired by a civil court of the competent jurisdiction. Or if it is found that Dolo Govinda Lanka, the opposite party number 6 did not have any exclusive absolute title to transfer. The same deed has to be cancelled by a suit established by a suit instituted under Section 31 of the Specific Relief Act. Stop. All this complex question of facts cannot be adjudicated under proceeding under Article 226 of the Constitution. As such, we dismiss this petition granting liberty to the petitioner to approach the civil court. Stop. In terms of the above, yes, there should be no order is to cost. Next.
Item 11. Last occasion, your lordship had directed the registry to verify whether that noting that notice has been delivered.
Yes, so this
Delivered. Meaning that notice on the respite.
No, the 5, 6, and 10. Appears from the list is no date, note that notice sent on the opposite party, the respondent's number 5, 6, and 10 have been delivered, but there is no representation.
Rabbi Dhanuj Kumar Sahu is appearing for them.
He is appearing for the railway, which now.
Yes, ma'am. That Sabita Ranjan Patnaik is appearing for railway. Whereas Dhanuj Kumar Sahu is appearing for those.
My lord, I am appearing for my lord Chandrakant Pradhan, my lord, I am in BC.
You are appearing for whom?
For OP1 railway.
It's for respond number 1, my lord. Yes.
Respond number 1.
Section 2. You are appearing to the private respondents.
This is the values sent
No, you
to.
can appear. That is what is. Mr. M.K. Kamtiya and the counsel appears for the appellant. Mr. Chakradhar Pradhan and counsel, senior panel counsel, you are, no? Mr. Pradhan, you are senior panel counsel. Senior panel counsel, Government of India, appears for the respondent number 1. And Mr. Mishra?
I am appearing for respondent number 2.
And Mr. S.K. Mishra and senior counsel, assisted by Pragya Mahathi is there?
She is here. Your lordship, she is here.
All
She
right.
is there. You can
Assisted by
hear
Ms.
it.
Pragya Mahathi and counsel appears for the respondent number 2. There is no representation for the other respondents. Though it has been recorded that the notices are properly served. That the matter is listed on 27th of September 2020.
While earlier said, but that's a very small matter, you also can take up it in earlier.
So what is the matter? Tell us, then today itself we'll decide.
That's the fixation of inter-se seniority only.
All right. Is it just come? What is the rule of the senior fixation? Are you ready, Mr. Mishra?
Your Lordship may fix it at any date, Your Lordship pleases, I will assist, my lord.
Oh, not
But
today.
today I thought it is actually miscellaneous purpose. I may be
12th
pardoned. I could,
September. 12th of September.
My lord. 12th.
As agreed by the council who is appearing before us, let the matter be listed for disposal on merit on 12th September 2023. So,
May I pray on that day at 2 p.m.? Can we taken up only 20 minutes? Hardly.
no, it will be just mentioned on that day. We'll fix.
My lord. Oblige. 8:14.
oblige.
In my lord, there is nothing that defects are there, but start me 10 days time, I will remove it.
Nothing defects are there. Why the 10 days?
Yes, my lord. Steps for limitation not taken.
Your appeal is barred by limitation of 45 days. You have not filed any application. And you are saying apparently there is no defect.
No, I said there is defect, I will remove.
Let the matter be listed on 12th September 2023. In the meanwhile, the appellant shall take appropriate steps for removing the defects.
Steps for
removing the defects. The appellant shall also take steps for service of notice. Within 3 working days from today.
You file requisites also.
Requisite by registered post. Stop. Mr. P.K. Mudali appears for the appellants.
The interim order is there.
Interim order is first, earlier should continue. How the appeal is barred by limitation?
Since the matter, Honorable Single Judge decided the matter relying upon one judgment which has been stayed by the Honorable Apex Court.
All right.
Item 15.
Item 15, I'm in VC, my lord. I'm appearing for the appellant. Here, actually, what has happened, the opposite respondent number 4, that is the CDPO, they have filed a counter affidavit and they have taken some new facts. So I think a rejoinder is required. So I may be given some time for filing the rejoinder, my lord.
At the request of Mr. J.K. Acharya and Senior Counsel, GK. Senior Counsel appearing for the appellant, let the matter be listed on 26th of September 2023. Meanwhile, the rejoinder, if any, may be filed against the counter affidavit filed by the respondent number 4.
Yes, my lord. Yes, my lord.
Filed with the respondent number 4. Mr. Patnaik, you are appearing? Mr. A.K. Patnaik, counsel appears for the respondent number 5 and appears for the stuff. Mr. Khuntia is appearing for?
Yes, my lord. 1 to 4. State respondents I am appearing.
1 to 4?
Well.
Yes, appears for respondent number 1 to 4. Yeah. 1 to 4. Okay.
Item 16.
In item 16,
yes,
2 IAs are there. One for dispensing with, another for condonation of delay, my lord.
There is a delay of around 10 months, Your Lordship. And for the respondent.
So you'll file objection?
Yes, Your Lordship. Because Your Lordship kindly see the IA application for condonation of delay, what ground they have taken. IF number 4.
All right. If you want to file the objection,
I'll file my objection, Your Lordship.
But the other 2 applications we dispose of.
As Your Lordship pleases.
Heard Mr. M.K. Kunthial and counsel appearing for the appellant slash applicant, also Mr. J. Biswal and counsel appearing for the, you are appearing for all the respondents?
Yes, Your Lordship.
Cover the opposite parties. This is an application for dispensing with the filing of the certified copy of the order dated 17/4/2019, passed by the learned civil judge in WPC number 23361 of 2021, which has been challenged in the connected appeal being WA 459 of 2021. Stop. Mr. Biswal, Mr. Kuntial and counsel has submitted that one photocopy of the order dated 17/4/2019 has been unclosed with the memorandum of appeal in lieu of the certified copy. Having regard to filing of the photocopy of the order, impugned order, we dispense with the filing of the certified copies, subject to condition that the certified copy shall be filed within 30 days from today. Stop. In terms of the above, this application stands allowed, disposed of. Then come to 1128 of 2021. This is a hard Mr. M.K. Kuntial and counsel appearing for the appellant applicant. This is an application for condonation of a delay. According to the stamp report, there is a delay of 754 days.
That's some COVID period will be.
No, just already you have expressed perhaps.
Well, in the application, no, Your Lordship.
No, that we are mentioning the stamp report clearly. Stop. In filing the intercourt appeal from the order dated 17/4/2019, passed in WPC number 23361 of 2012 by the learned civil judge. Stop. Issue notice as to why the aforementioned delay shall not be condoned or any other order shall not be passed in regard to the circumstances of the case. Notice is made returnable on 27th of September 2023. Since Mr. Biswal and counsel, J. Biswal and counsel PSN was noticed for the opposite party, no formal notice is called for. Just you supplying a copy of the memorandum of appeal?
It is with me, Your Lordship. Already supplied.
All right.
Not on limitation.
Yeah. Just wait. I think limitation has already been allowed.
Limitation not allowed.
Okay.
No, limitation not allowed.
No, this notice was issued. Then in this IA 1128 of 2021, this simply at the request of, don't screw up the entire matter. Say that there is at the request of Mr. J. Biswal and counsel, it came to the opposite parties. Let the matter be listed on 27th September 2023. Meanwhile, the opposite party may file their objection if no further accommodation will be made for the same purpose. Mr. M.K. Kuntial and additional government advocate is required for the appellant. Okay. It is on the 24/7 notice was issued earlier.
Item 17 also said.
Order is passed earlier, shall continue till the next date. In IA 1130 of 2021, there is an interim order.
It may have passed ex parte, Your Lordship. In absence of my presence, that may have been passed. In absence of my presence, that may have been passed, Your Lordship.
So file an application for vacating. Till the next date, we have done it till the next.
Yes, Your Lordship.
Item 17.
Item 17 also same, and item 16. 17, 64, 65, 66, 68, 70, and 71. There are similar matters, Your Lordship.
Just give the.
I'll give a slip, Your Lordship.
So similar orders will be passed and on the same date that will come.
64,
64. Numbers and prepared orders. Yes. Next.
Item 18.
Item 18, Your Lordship, give me some more time. I will remove the defects. That paging not.
All right. When the matter was listed on 12th September 2023 at the request of Mr. M.K. Quintil and consolidated with the appellant. Meanwhile, the defects.
That page marking not done properly, so
the defects, yes, it is the defects as identified by the registry shall be removed. Defects relating to the pagination.
Only pagination. I'll do that within.
All right.
Item 19.
Yeah, please, Lord. Item 19, my lord, there is an application for amendment of the cost title that was done. And the rectification application is more important, my lord. If your lordship kindly, on 28 July, your lordship had directed them to file to seek instruction with regard to 10,000 metric ton. Actually, my lord, in the interim order of 2021, 5th October 2021, there was
direction mentioned as 1,000 instead of 10,000. So that can be done. That is not a. And so far as the reply counter is concerned, since the amendment application is to be allowed, so we will be granted 7 working days time. We'll file a reply. It is ready, but for that, because of the change on the last occasion, your lordship had stated.
Having reduced the nature of the amendment is proposed by this application, and having heard Mr. We have Dr. Kedarnath Tripathi, Planet Counsel for the additional applicant, and also Mr. B.P. Nandan as a senior advocate is appealing for the opposite parties. We allow this petition by permitting the appellant to carry out the amendment. You have not made out any schedule.
My lord,
Schedule was scheduled there.
Schedule with regard to
the
amendment.
So that is only the cost title. Yes, that is to be.
It is the last page.
Yes.
As per the schedule of amendment as appended to this application. These first and allowed. The petitioner applicant is directed to you file amended cost title.
A consolidated cost title. I have already filed along with that.
It has been stated by Mr. Learned Counsel. It has been stated by Mr. Tripathi and Dr. Tripathi and Counsel for the applicant that amended cost title has already been filed. It is to directed to incorporate the amended cost title. Stop. In WPC was in order the request of DP Nandal and Senior Counsel that the matter be listed on 12th September 2023. Meanwhile, the additional counter affidavit.
No, we had not filed earlier. We were supposed to file. Yes, we'll file it within some
counter affidavit shall be filed by the opposite party without fail.
Yes.
So far as the rectification application is concerned, it is only that rupees 1,000 is to be changed to 10,000.
Not rupees, I think metric
No,
tons.
that's ton, metric ton.
Metric ton. It should be
Metric tons.
kindly.
So 1,000 metric ton, it will read as 10,000 metric ton.
That is IA number 140.
Administrators agencies and also administrators agencies. This is the order, relevant order is dated
5th October 2021.
In the order dated 5th October 2021.
Madam.
Yes. IA number 10026
is on the basis of the erroneous pleading, which has been amended. No, the pleading was correct.
Pleading was there.
All right.
It's a typographical error.
Inadvertently, while describing the quantity of the balanced material stuff, instead of 10,000 metric ton of 50%, what is the 55%?
Fe, that is the iron content, the ferrous content in the
of 50% Fe from the respective stacks as per the contract. It has been typed as 1,000 metric ton of 50% Fe. So, Mr. Nandal and Senior Counsel has really stated that this mistake should be corrected accordingly. We correct the order dated
5/10/2021.
5/10/2021. Passed in IA number 14036 of 2021. So, of the correction, the relevant paragraph at the bottom of page 1 of the said order shall read as follows. As far as interim prayers, to allow the petitioner to lift the balance materials of rupees 1,000 metric tons of iron ore is concerned, from a pendency of this writ petition shall not be a bar for the opposite parties to the materials of 10,000 metric tons. Is concerned, tendency of this writ petition shall not be a bar for the opposite parties to consider the prayer for the petitioner to leave the materials. Unquote. Stop. Is copy of this order shall form the part of the order dated 5/10/2021. In terms of this application.
In fact, entire amount has been deposited at that point of time only.
This is not the part of the application. That is a separate part of the okay, next state. Let them file the counter affidavit now.
We'll do that.
Yes.
Item 21.
Obliged.
My lord, 1 minute to withdraw my.
Have you filed the memo?
Yes, I already filed.
Check whether the memo is there. Yes. I filed. Yeah. In I number 2546 of 2023. This is item number 41. You are Mr. K. Swine.
Milo?
You are Mr. Your name, please.
On verification, I'm PK Mahapatra.
PK?
PK Mahapatra. My power is
Mr. PK Mahapatra and Counsel, having appeared on behalf of Mr. KK Swine and Counsel for the appellant, has submitted that the appellant will not pursue the appeal anymore. And as such, this application for withdrawal may be allowed. So we do not find any impediment to allow the appellant to withdraw this appeal. So in terms of the above, this application stands allowed and disposed of next in WA in view of the order passed today in I number 2546 of 2023, this appeal stands dismissed as withdrawn.
Item 22. Item 22, I sort of accommodation, my lord, that on last occasion, your lordship had directed me to take instruction whether any juniors have been regularized or not.
Yes.
I'll take instruction on that only. Your lordship may give me 7 days time.
I have enclosed the document, my lord. No instruction is necessary. Petition is in the hall of retirement. The opposite respondent, my lord. I have enclosed the document. That is the order. The order was passed on 20th of April 2023. They are referring to the documents I have filed in my rejoinder. The Honorable Court passed the order that you take instruction. But there are documents, my lord. I have enclosed.
Rejoinder.
And yes. In the rejoinder affidavit filed before the
come to
unknown single judgment.
With the writ petition.
Yes. Before the
where is the document?
Before the unknown single judge, I have filed a rejoinder affidavit, and therein I had enclosed all the documents, my lord.
And the order says point out that document.
That rejoinder is not with my file, my lord. That's why
rejoinder also is not with our record.
So that's why I am seeking only 7 days time. He is objecting to that also.
I am not objecting. I am objecting to say that order was passed on 20th of April 2023.
But this record is not in the file, case file. Just check up.
Record of the court
rejoinder is available.
That is there, my lord. Read that.
This is before the tribunal.
Yes. Tribunal that was transferred to this honorable court, my lord.
That
is nothing is also there, my lord. The record is here, my lord. The list.
This way records is there or not?
List only.
Judicial record is
number convert is.
That is WPC OA 3240-2013. That has been renumbered as.
Well, that rejoinder is there with that file. Where? This 3240-2013? Yeah. What is that? Counter was the copy of the rejoinder is not. 60 and 68. Yes. 60 and 60 to 68. Oh, this is the rejoinder. But where is the you have it has been filed. Page 60 to 68 of the running page.
Well, that file is not with me, that only readable file. So for that reason, I am seeking only 7 days time that I have to verify those documents.
8th of September, shorter date. At the request of Mr. MK, you just give a copy of the rejoinder to him.
It would be better if he gives me a copy. I will take it.
At the request of Mr. MK Kundel, an additional government advocate appearing for the state opposite parties. Stop. Mr. Arun Mishra.
My lord, is state council, my lord.
You are appearing for this. My lord. At the request of Mr. MK Mishra, additional government advocate is appealing to the appellant when the matter will be registered on 8th of September 2023. You are Mr. R. Mohanty.
Yes.
Mr. R. Mohanty, counsel appears for the sole respondent. We would request Mr. Mohanty to supply a copy of the rejoinder that has been filed in WPC OA number 77. Let me the number. To Mr. Kuntia in the course of the day.
Item 23. Item number 23.
Mr. Roth is a person, so Mr. Sunil Kumar.
Not present.
Last occasion also he was not present.
In person he is appearing. Last date he was
public interest litigation. Let us give a further date. And the matter will be listed on 18th of September 2023 as none appears with the appellant. Our Mr. Devkant Maharti One addition GA appears for the state and Mr. S.K. Kaur. Mr. Kaur is also not here today.
No.
And none appears for the others remaining respondents. All right.
Last 2 dates you were not present.
No, probably it was speaking.
Item 24.
Mr. Mahathi, have you filed a reply to that early petition?
No, I think notice has not been issued, I think.
All right, let us see on the next one.
Item 24.
May I please, Your Lordship. In this matter, the petition is challenging the order of the learned single judge. The petition was filed challenging the recovery of the petition appellant's pension gratuity among my lords. The learned single judge disposed of the writ petition, saying that since on the basis of the recovery was made on the basis of audit objection, my lords. The learned single judge disposed of the writ petition, saying that since appeal lies to the triangular committee, so you file an appeal, and therefore this writ petition is not met. My submission before your lordship is that since according to section 4(6) of the Payment of Gratuity Act, this recovery is not at all tenable, so therefore the petitioner doesn't need to file the appeal, and this recovery
This section 4
matters.
the payment of gratuity. Yes.
Your lordship kindly have placed subsection 6 of section 4.
Yes.
Matters. Notwithstanding anything contained in subsection 1, the gratuity of an employee whose services have been terminated for any act, willful omission or negligence causing any damage or loss to or destruction of property belonging to the employer shall be forfeited to the extent of the damage or loss so caused. The gratuity payable to an employee may be wholly or partially forfeited if the services of such employee have been terminated for his riotous or disorderly conduct or any other act of violence on his part, or if the services of such employee has been terminated for any act which constitutes an offence involving moral turpitude, provided that such offence is committed by him in course of his employment. Well, in this present case, they are making the recovery based on the audit objection, which was made 5 years after the petitioner's retirement, my lords. And since the act which they are alleging
5 years, you did not get the gratuity.
No, my lords. In 2005, they made this recovery by sanctioning the gratuity amount after several recommendations, and thereafter they recovered the gratuity amount on the very same day.
Who is appealing to the state?
I am for the corporation matter.
Oh, corporation.
But this is the second out of writ petition. First,
What is the first round of writ petition?
First round of writ petition, I have filed an additional affidavit back to my direction.
There is the writ petition of 2002.
That was the first round of 2002.
Yes, yes.
As per my directed on 18/11/2022, my lord, this was division then directed to file an affidavit. I filed an affidavit or pursuant to my direction. I will kindly go to that affidavit dated 20th March 2023 affidavit I have filed. 20th March 2023 affidavit I have filed in this writ appeal as per my direction.
Is it an additional affidavit?
Neither.
Additional affidavit?
Neither. By my direction.
Yes.
My directed to file the statutory backdrop. How did done? I have also filed a short death charge.
Always.
May place, my lord.
We are only not ULS, we are not concerned, we are only concerned with the gratuity.
No, US, Malaysia, annexure D, page 6 to apply agreement.
ULS is not this governed by this payment of gratuity act.
No. What we have done, Malaysia annexure D, he retired on 99, and before retirement, no due certificates were called for from demonstrations on 14/5/99 on the annexure 1 to the deed petition. Annexure 1 to the deed petition. And he retired on 31st October 99. On 14th 2000, he filed application, that is annexure D, that also counter in the document, but I filed it here. Page 6, annexure D to the additional affidavit.
Is
may I place that one. In consideration to my urgent request on medical treatment, Managing Director has sanctioned the above retirement benefits. I request you to please disburse the amount of urgency basis before February end to meet the medical expenses. In case of delays, OFDC will be responsible for the consequences. I undertake that any outstanding dues legally payable by me shall be recovered from my gratuity. This is the undertaking here. On that basis, ULS we have disbursed on that basis. Then
we are not concerned with the UL.
No, I am not, because of the I want gratuity. He, after retirement, he says my gratuity will be don't pay, not pay, will from my gratuity amount. When the loan certificates came, that was some huge amount was found out on that. Then he filed a written in 6/7/2022, that is page 11 of the additional affidavit. He approved this honorable court. Page 11 of the additional affidavit. The petitioner retired from service and attaining the age of superannuation on 31st October 99. The only grievance of the petitioner in the petition is that authorities are not releasing gratuity amount payable to him. But then a stand having taken by the opposite parties to decide that as certain recoveries, unrecovered amount are outstanding against the petitioner, gratuity amount is not being released. In view of the said submission, I dispose of the petition directing the opposite parties to take decision on the representation said to have been filed by the petitioner. On scrutiny, it is found that the active petitioner is entitled to receive certain amounts towards the gratuities that shall be taken to payment for the same. Actually, the possibility for within a period of 3 months. On that basis, my lord, that was in 23rd October 2005.
Yes.
Then, on that basis, the audit paras which are received against him were sent before triangular committee formulated under annexure 382/2000. There is triangular committee annexure E to this affidavit. That is at page 7 and triangular committee to consider all the cases. Retired person dues, audit reports coming after the retirement. He is the general manager. He is not an ordinary clerical staff, not a field staff. He is general manager of the corporation, the highest rank officer. And all these audit recovery were paid by the triangular committee. Triangular committee considered that, considered the objections received from the compliance report received from the division officer and returned this certain amounts. That, my lord, is or some amount determined by the triangular committee. Those documents are annexed to the counter in the writ petition. They are counter in the writ petition. That was done on the basis of this board resolution dated 3/2000. As per the Mayor's order, matter placed with the triangular committee, determined certain amounts, saying should discard many and allow only few. That is my representing with my lord. I can place that para. In my counter, Mayors have determined The committee met and one committee said, first committee, out of 16, 17 lakhs, they have said only for this recovery of 1,20,000, amount set to 378. For this further complaints for 11 lakhs, amount related to the not this. So only 1,20,000 in one committee meeting, and the other meeting there is some 100 lakh, and other they are left scot free because of that. And only because of this order, on the basis of these findings, Annex 3 to the petition, the managing director has passed the order. Saying, so this 2,50,000 was the gratuity sanction. Out of that, they have said we will not pay the gratuity. That was imposed before the honorable single judge. Honorable single judge had the letter and said, you file an appeal. That is the file.
Well, Council, you just few minutes back you have stated that this triangular committee has already considered his matter.
Yes,
what further improvement can be expected from that committee?
Appeal. Appeal is there against the order. Now, Rule 131, I have understood.
If you agree, the statutory provisions provides that there should not be any deduction from the gratuity unless that has been established by a proper disciplinary action on the after framing the misconducts.
This part was never before single judge. This appointment, whose my friend now arguing, are not before the single judge.
No, it is a question of law. It is the first step.
No, he challenged the judgment of single judge.
All right, in the same ground.
I don't know.
The same ground. Because he has become non-suited because he said the writ petition is not mentionable.
Only if you want to see the last single judge for language.
Yes, which is, what is the order I am searching out?
On single judge order, I am listening.
Page 10 of the
Hard Council with parties at length, query the material available on record, had clearance an amount of 7,11,000 is sought to be recovered from the petition of gratuity in consonance with the audit report, which are confirmed by the triangular committee. Law will also settle that against the order of passed by the triangular committee, an appeal lies, as the petition has not preferred an appeal in the aforesaid facts and supports, cannot issue any writ of random or directing provision to adjust, not to adjust the dues from the amount payable to petition for gratuity. In view of the own letter and
the core of the provisions. He has not mentioned the provision, but this is the core of the provision, not to deduct any amount. And this gentleman is suffering from 2002.
Yes, but he was gentleman. He came
We did not grant any interest, but we direct you to release the amount. If you agree, of course.
I cannot agree officially, but for before my I know the things, but
there is a problem because you are not denying that you are not liable to pay this.
That is an undertaking that was said by them to give that so that I can avail the unutilized leave salary, that you give the amount. Yes. But I have stated that legally payable. If it was legally payable,
because you are payment of this, your own this corporation is suffered here under all circumstances you have to pay that. Only because not from this year, but I do not know whether they have recovered any money from your unutilized leave salary.
No. Because undertaking paying the salary. He said, I might have available.
Even I have annexed the notification of the government of Odisha Finance Department. They are also yes, my lord, that is applicable, my lords. Even there also they have stated that this audit of report objections, the gratuity should not be gratuity amount should be recovered for satisfaction of the audit objection report. That is also annexed in the petition.
Do you admit that you are liable to pay that amount? They are showing because you have not challenged anywhere. I have not found the audit report you have challenged. This is incorrect, inaccurate audit report. Have you stated anywhere?
He was technically proceeding.
Well, the petition was never allowed to take part in the proceeding.
Then I am directing them to pay the gratuity, and also directing them that you have admitted that you are liable to pay that amount, and you will deposit that amount after drawing of your gratuity. They will not deduct. Can the court pass any order that you are just overlooking the damage that caused by your action?
Hello, sir.
And the 5-year theory will not apply because the within 5-year action has been taken against you.
But that action has been taken by virtue of a provision which came by way of amendment after 5 years of my retirement, which has no retrospective application, only prospective application. No, that has also the similarly situated another person similarly situated to that of petitioner, whose matter was decided by this honorable court.
What is the judgment?
Well, that I have
That I have seen. I have pending. In that case, had to ask. Bangalore has not pending. That is pending with Bangalore Committee. Not decided. What is that? Have decided and observed past.
Pending, we cannot look at that.
That is only pending. You know, I can say. Only my thing is, he proceeded technically because he is he managed to take the amount by the undertaking giving. I mean, that is available.
No, because of this provision, perhaps without Department of Proceeding, yes, you cannot recover anything from gratuity.
That is right.
So on that ground only release that and what to do now?
250,000 without 250,000 will release without interest perhaps.
Without interest, yes, because you are not paying the damage.
Always 7 lakh
another similar situated person which I am.
The damage you are not refuting that you are not able to pay the damage. Instead, we are not granting you the interest.
Okay.
That whatever the damage that will be actually virtually an adjustment. Admit that position. Otherwise, that will be complicated. We will direct them to start a proceeding because you enjoyed your before the court over that issue. Just think about that. Because you have asked for the interest.
In that case, also 12% interest has been granted to the.
I don't know what that case is. This is an appeal has been pending before that order. So it is not finally decided as yet.
Well, since in that case, this impugned order was relied and the learned single bill has negated the order, impugned order.
There is also a decision of Honorable Delhi High Court. 13 will not be a bar. In said matter. You can realize it. I have got that. Since matter can give, I would rely on any matter. Relied and they held that. One suppose they relied and said, I am not without.
Don't dictate the order at 2.
That will not be bad. That's it. Because the dues of the corporation we can talk.
No, he's not.
What I accept.
Subsection 6.
That is not 13. That is
not. Supreme Court has subsequent that if not terminated, there has to be disciplinary proceeding pending for the recovery.
There are so many outcomes.
Recent judgment is different.
You'll observe this since there was no disciplinary proceeding.
I know.
But will not grant you interest. We are satisfied there is some amount you are liable to pay there. So we are not going to square up the matter. Pay the gratuity.
Only a limited in the mirror. Now what has happened with the my lords? The gratuity amount that which say they are saying that is 2.5 lakh, that is actually 3.5 lakh. That has also been notified by
whatever the gratuity amount you will be entitled to get under section 4, subsection 1, you will get that.
I just want 2.5
lakhs. According to the section 4, subsection 1.
And section 4, subsection 6 only, they have notified that the gratuity amount has increased from 2.5 lakh to 3.5 lakh with effect from 1997.
I have filed that document also.
That according to that is why I am telling you this subsection section 4 subsection 1 was amended in 1999. You will get the amount quantified under that section. This is
not only humble submission.
Accept that. Spell out that according to the amendment rule, only you will be Gratuity and they will pay.
I have filed the account account also.
In 1999, 2.5 was enhanced to by notification to 3.5. If gratuity will be calculated according to the amendment provision, then you will get the 3.5.
I have given the application counter itself. In the which code I have given the count 3 lakh rupees I have filed. We'll get
What point? No.
We'll get 35.
Already correct. Get the order in the court.
There is an item 32, is a probationer has been directed to be reinstated. Can it be taken up any day next week? Today is not possible to reach you. Correct. Grateful.
Just wait. Matter come.
Item 24.
One nine one of 2024. You are Mr. A.K. Mahapatra.
I don't have power in this matter. I am appearing on behalf of Mr. A.K. Mahapatra.
Say, what is your good name?
Vivashwat Mahapatra.
Yes, Mahapatra and Council appears an instruction of Mr. A.K. Mahapatra and Council for the appellant and Mr.
S.K. Patnaik. Santosh Kumar Patnaik.
No, Mr. S.K. and Mr. S.K. Who is assisting you?
K.K. Patnaik.
Yeah. Senior counsel, assisted by Mr. P.K. Patnaik, and counsel appears for Orissa Forest Development Corporation. So, by means of this intercourt appeal, the appellant has challenged the order dated 1/9/2008, passed by the learned single judge in WPC number 16071 of 2006. By the said order, learned single judge what is the date? What page the order is there?
At page 10 of the reader. Page 8 it starts, page 10 is the operating.
Page 10. This is the Justice Naidu's order.
My lords.
The single judge has observed that fact remains. This is page 10. para 6 of the judgment, not entered after first line. An amount of rupees 7,11,869 is sought to be recovered from the petitioner's gratuity in consonance with the audit report, which was confirmed by a triangular committee. Stop. Law is well settled that against the order passed by a triangular committee, an appeal lies, and the petitioner has not preferred any appeal. In the aforesaid facts, this court cannot issue a writ of mandamus directing the corporation not to adjust the dues from the amount payable to the petitioner towards gratuity. In view of his own letter, annexure A to the counter affidavit, clause, the petitioner is stopped from taking such step. This court therefore disposes of this writ petition, giving liberty to the petitioner to file an appeal, assailing the decision taken by the triangular committee. If such an appeal is filed within a period of 6 weeks, the same shall be entertained, weeks hence, the same shall be entertained and disposed of on its own merits. Realization of the amount, if any, from the gratuity will be subject to the result of the appeal. The appellant, without taking that recourse of filing appeal, has challenged the very order passed by the honored single judge by means of this appeal. Stop. Learned counsel for the appellant has stated that the law has decided the observation, the opinion of the learned single judge is not sustainable in as much as when a order is passed against the express provisions of the statute, it amounts to invoking a jurisdiction by the authority which is not vested with him. And in such circumstances, the writ petition can be filed even if there is alternative remedy of filing an appeal. So, in this regard, reference has been made to subsection 6 of section 4 of the Payment of Gratuity Act 1972, which provides as follows, quote that word. Stop. When counsel for the appellant is contended on the basis of the same provision that the gratuity can be forfeited wholly or partially in the event that an employee has been terminated for an act, willful omission or negligence causing damage or loss to or destruction of the property belonging to the employer in order to recoup the damage or loss. So, the another circumstance under which such forfeiture can be named, if the services of such employee is terminated for his riotous and disorderly conduct or any other act of violence on his part. Services of the employee have been terminated for any act which constitutes an offense involving moral turpitude, provided that such offense is committed by him in the course of his employment. Stop. There is no dispute that the appellant was never terminated for any ground, as therefore noted. SR's learned counsel for the appellant has contended that in the present case, there will be no order of making recovery from the gratuity. Gratuity is, the recovery from the gratuity is protected, save and except the circumstances as noted above. Stop. As such, the relief spread in the reputation being WPC 16071 of 2006 ought to have been allowed by the learned single judge, but the learned single judge by the influent order has dismissed the writ petition, reverting the petitioner with liberty to file an appeal from the order of the triangular committee. Stop. The relief sought in the writ petition is that by the decision of the triangular committee available in committee dated 26/12/2005 as reflected in the decision of the triangular committee as reflected in the order dated 26/12/2005 will not be quashed, and why the petitioner shall not be paid a sum of rupees 3,50,000 towards gratuity with interest at the rate of 12% per annum with effect from 1/11/1999, the date of retirement of the appellant. Stop. The petitioner has in respect of the damage stated in para 9 of the writ petition as follows. The opposite party by order number 895 dated 26/12/2005 issued an order sanctioning rupees 2,50,000 towards gratuity in favor of the petitioner. Though under the Payment of Gratuity Act, he was entitled to rupees 3,50,000. So further, the opposite party, without disbursing the amount so sanctioned to the petitioner, adjusted the same towards alleged recoverable dues. In the said order, opposite party also showed a sum of rupees 7,11,869 as outstanding recoverable dues against the petitioner, allegedly on the basis of audit reports mentioned therein. The opposite party further directed that a sum of rupees 4,61,869 is to be recovered from the petitioner by instituting a legal action after adjustment of rupees 2,50,000 sanctioned in favor of the petitioner towards gratuity. Stop. Mr. Patnaik, learned counsel, senior counsel appearing to the corporation, has fairly submitted that no further legal action has been taken. Mr. Patnaik, no legal action has been taken by the corporation against the appellant. Stop. Having appreciated the submissions of the learned counsel appearing for the parties, we find there is sufficient force in the submission of the learned counsel for the appellant. Stop. The exercise that has been taken by the respondent corporation is wholly in contradiction to subsection 6 subsection 4 of the Payment of Gratuity Act 1972. Stop. Hence, the said recovery is bound to be declared as illegal. However, as regards the liability as determined on the basis of the audit report, could have been determined to the process of law, which has not been done, and the appellant has categorically in his writ petition stated that he doesn't admit such liability. Stop. In the circumstances, we direct the respondent corporation to make payment of gratuity to the extent of rupees 3,50,000 within a period of 30 days from today. But we are consciously not giving any interest, considering considering that even if there may be some damage and determination, considering that aspect of the matter, that the audit report cannot be totally ignored by this court. Mr. Learned Counsel for the appellant has submitted that determination of 2,50,000 as the gratuity. As the Learned Counsel for the appellant has stated that the gratuity had been determined at 2,50,000, ignoring the amendment.
Madam, may I intervene 1 minute? That amendment came into force. Another C to the 2007.
No. Before that, there is just a minute. If that is not there, I will not do that.
No, it is there. 2007.
No, that I'm just showing you this. It isn't 4, I thought.
Annex C dated 2007.
Annex
separate from the interpretation.
Annex C to the counter.
Huh? No, what is the provision? The provision has been amendment. Show that provision.
4.3.
4.3.
Okay. (24.9.97). Government to in this
has come
24.9.97. But that order in corporation issued on 18 January.
You have notification of the central government.
24.9.97.
I don't have notification, but I have notification of the OFDC, my lords.
Where is their notification?
Annex C.
Annex C, my lords, to the counter affidavit.
Clarified in 2007. Board decision.
Page 20.
Yes, it is with effect from
97.
24.9.97.
So this is given. Decision came later.
This. What's the last one? What was the last one? Amendment carried out in section 4C of the payment of 4.3 sub with the 3 of the Payment of Gratuity Act 1972. Stop. Even from the Office Order number 71 dated 18th January 2007, it is clearly evident that the amount ceiling of gratuity of rupees 3.5 lakhs has been given effect from 24/9/1997. As such, the appellant is entitled to get the sum of rupees 3.5 lakhs as the gratuity stub. Since we have stated that no recovery is permissible in view of the fact that there had been no valid proceeding for the recovery, and as the petitioner appellant has retired with effect from 1/11/1999, the payment of the bare amount of the gratuity will draw a closure on the controversy. There shall be no orders to cost. A copy of this order is supplied to Mr. Patnaik, Learned Counsel, is appearing for the corporation.
Now the process closed. Now the litigation closed.
No, because this entire process is wrong. You can understand. No, recovery cannot be done in this process. The audit report and so directly come. There should be a semblance of proceeding.
That could have been done at that time.
But I have not collected that may be unjust. But bury the entire contract.
I am very happy for the
yes. Now for the other matters. Yes, sir. This is the item number 41.
41. On that. Item number 41, my lord. I have given my note of assumption. Yes. I am also filing my note of submission today.
Yes, you are also filing it.
My lord.
Have you gone through this affidavit filed by the respondent? Short affidavit, 1 page.
No, your lordship, I have not been served with a copy of that.
Mr. Muduli, you have not served that copy.
So he was not there in the morning. I have sought on Mr. Ponda. I have sought.
So they have just said that was a bona fide mistake. Order will be something like that. I think it is nothing to object in that. They are not.
That point is covered in my note of submission, your lordship.
Huh?
That point has been covered in the note of submission, sir.
I don't know, 41.
Right, 40.
I was mentioning about item 32, my lord.
Just a minute. Mr. Panda, you are appearing in which matter? WBC
Yes.
Learned Counsel for the petitioner. In WPC, Mr. S. Shekhar, Learned Counsel for the petitioner in WPC number 19875 of 2029. It's filed a short note of submission. Whereas Mr. P.K. Muduli, the additional government advocate, has filed a short affidavit to point out that in the letter dated 13/8/2007 of 18 candidates to the post of ASO by order dated 10/11/2010 and releases 7 to the writ petition is a bona fide error. Stop. Mr. Shekhar, Learned Counsel, appearing with the petitioner, has submitted that petitioners in the note of submission is submitted by the petitioner. That point.
Okay, I'm filing my note of submission now. Okay.
Mr. A.K. Panda, Counsel, appearing for WPC number 30991 of 2020, has also filed a written brief of submission. So, All these note of submission and the affidavit are taken on record. The hearing is complete in all the analogous matters. Reserved for judgment. Yes, Mr.
Interim orders are there.
Interim orders will automatically conclude. They are reserved for judgment. It is not required. The interim order will continue. Yes.
So item 32. This matter relates to service of one of the probationer who was, his service was dispensary during his probation period, but the Honorable Single Judge has directed to reinstate with all benefits. But we have allowed him to join, though it was, writ appeal was filed. And the matter will be taken up any day next week, but because now today it's not possible to be taken up.
Next week is very difficult.
There's a fixed date so it can be taken up already.
27th of September.
22nd, 27th.
27th.
7th.
Which one? For disposal on merit on priority.
32.
Mr. Parida is not there on record?
No, he is assisting me, but he is not there.
You are appearing on a Prabhu Prasad Mahanti.
No, he is for the appellant.
Prabhu Mahanti, or he is actually.
No, you are for the appellant, I think.
Appellant.
On instruction of Mr. Prabhu Prasad Mahanti. And counsel. You just inform Mr. Buddhadev Rautre who is appearing for the.
He is no more there. He is not there.
Mr. Nayak has come.
Yes,
Inform them, please.
I'll do that.
Or I think Mr. A.K. Roth also appeared in this.
Mr. Ratha, I think he is appearing. I'll inform you.
DN Roth is there.
All right.
Item number 26. May be allowed. Just to recapitulate my submission precisely on the other day that I had made for SUBHASIS.
Yes.
Yes, a dual approach was made in this case, the first matter was by the authority for the purpose of determination of the purchase value by determining the sale price where the same is more than the purchase price and determining the purchase price or the refined transfer price where the sale price is more than the active minerals. The dual approach.
We have shown that.
Yes, I have shown dual approach. And industrial gas also, we also have said, they have mixed both the prices of two distinct products, that is industrial gas and domestic LPG, and they have actually added 154 crores. Now, we have, for the last occasion, Royal Lordship's attention to Section 3, the charging provision, 4, and Section 2 mirrors, my Lordship kindly say, definitional provision, Section 2D of the Orissa Income Tax Act mirrors. Yes. 2D defines the expression entry of goods belongs. Entry of goods with all its grammatical variations and cognate expressions means entry of goods into a local area from any place outside that local area or any place outside the state for consumption, use or sale therein. Then you also have to see the definition of local area, what it is. That is definition in section 2F, local area. Local area means the areas within the limits of any one municipality constituted under the Orissa Municipal Act 1950, two Gram Panchayat constituted under the Orissa Gram Panchayat Act 1964, three other local authority by whatever name called constituted or continued in any law for the time being in force. Then and includes area within an industrial township constituted under section 4 of the Orissa Municipal Act. So these are the different local areas, because be it municipality, be it Gram Panchayat, be it industrial township, all this come under local area. Now we also kindly turn to definition for annex of 2Q millers. Only I am covering the definition, then I will come back. 2Q millers. 2Q says words and expressions used herein and not defined in the Act, means Indirect Act, but defined in the VAT Act, shall have the meaning respectively assigned to them in that Act. Then my lords may kindly see 2I. 2I is prescribed by rules, millers. Then 2M is scheduled goods. This is very important because tax is levied only on scheduled goods. Unless it is where the scheduled goods, it cannot be in the purview of taxation. Yes. Scheduled goods mean 2M. Scheduled goods means the goods specified in the schedule to this Act. Now, I will take a lordship's attention to section 37 of this Entity Tax Act. Section 37 is the power to make rules. So the state government shall, subject to the condition of previous publication, make rules by notification to carry out the purpose of this Act, provided that previous publication shall not be necessary where the rules are made for the first time after the commencement of this Act. Then my lords may kindly look for a while. Rule 17. Sorry, 2 is also important. I'm so sorry. 37(2). In particular and without prejudice to the generality of the foregoing power, such rules may provide for all matters expressly or otherwise required or allowed by this Act to be prescribed. It's a plenary power. In all respects, state has the power to make amendment. Rule provides to make rules. Then Rule 17. The other day, I have read for lordship section 2J, the relevant provision, and this is the corresponding Rule 17. It's a comprehensive rule, of course. The caption is deduction, exemption, assessment of tax. In determining the purchase value liable to tax under the Act, the amount relating to purchases made within the local area from a registered dealer carrying on business in the same local area shall be deducted. The purchase value shall be determined on the basis of the invoice, unless the same are rejected for reasons to be recorded in writing and after giving reasonable opportunity of being heard of the dealer to the dealer. Then 2, the purchase value of the scheduled goods entering into local area, which has already been subject to tax under these rules or on which entity tax under these rules have been paid by any other person or dealer, and for which the proof was specified in Sub-Rule 5 of Rule 3 has been furnished dealer, shall be deducted determining the purchase value liable to tax. 3, the purchase value scheduled goods brought to the local area but sent outside the state, otherwise done by himself, shall be deducted while determining the purchase value liable to tax under the rules. Well, precisely this is the rules. No mechanism is available for determination of value. It is not there. Barring only, because it says that if the assessing officer, while determining what to reject the invoice, then he has to give opportunity. But the modality of determination is not available in the rules. There is a notification. Of course, that also I have annexed along the petition. I will take your also little while after now, but that also doesn't speak of any modality. Now, I will once again take my lord's attention, my lords, to section 2J before I advance further, because that is the provision which is on a challenge.
Always.
2J, purchase value. Purchase value means the value of scheduled goods as accepted from original invoice or bill and includes insurance charges, excise duties, countervailing charges, sales tax, value-added tax, or as the case with turnover tax, transport charges, freight charges, and all other charges incidental to the purchase of such goods. This is very important because incidental to purchase of such goods. Then provided, which is under challenge, specifically in all the batch petitions, provided that where purchase value of any scheduled goods is not ascertainable on account of non-availability or non-production of the original invoice,
Yes.
or bill, or when the invoice or bill produced is proved to be false, or if the scheduled goods are required, maybe readily acquired, acquired or obtained otherwise than by your purchase, then the purchase value shall be the value or the price at which the scheduled goods of the like kind or quality is sold or is capable of being sold in the open market. Yes, this pinches us. That is why we are all equal belows. That means belows, it speaks of two things belows. One is if the goods are brought into the state belows accompanying with the purchase invoice or bill, and that is found to be in order, then the value disclosed shall be accepted belows. Secondly, if bills or purchases are produced, but that is found to be not satisfactory, false, fake, then that is liable to reject it. Following Rule 17, an opportunity granted, and after that, the officer has the power to reject it. Third, which is very important in this case, in a case where goods are acquired or obtained other than when you purchase,
Yes.
then in that case, the provision says that the value or the price shall be the price of similar goods, not that goods, similar goods, which that will fetch if that will be shown in the open market.
So sort of a best judgment method.
Sort of
Best judgment assessment.
best judgment, and it's unbridled. It's unbridled and ungoverned power. The power should have been, there must be some code, there must be some methodology, some mechanism. Nothing is there. It is left to the assessing officer to sell across any one way. He may assess somebody in the purchase price, maybe some sell price. If sell price, nobody knows what is the retail price or wholesale price or the sub-wholesale price, because price index varies. It is arbitrary. So no mechanism, nothing. Now we are entry 52.
So the one of the ground is uncanalized power.
Unbridled and uncanalized power.
Yeah, power and cast upon the assembly.
That is unbridled, uncanalized power. Then, while we are looking at 2J, my lords, once again may kindly see the charging provision, section 3. Because nothing can traverse beyond charging provision, my lords.
Yes.
So section 3, my lords, may kindly see for a while. Section 3 provides for levy of tax. 3.1. There shall be levied and collected a tax on entry of scheduled goods into a local area for consumption, use, or sale therein at such rate not exceeding 12% of the purchase value. My lord, may kindly bear in mind this. Of the purchase value of such goods, means such scheduled goods, from such date as may be specified by the state government, and different dates and different rates may be specified for different goods and local areas, subject to such conditions as may be prescribed. Second, your lordship need not, because it says that composition, one can pay the tax in composition, that is not required. So, what precisely section 3.1 says that if there is entry of goods into a local area, mere entry of goods doesn't invite tax liability because entry of goods for the purpose of use, consumption, and sale therein.
Yes.
That is judgment. I will take my lord's attention, Tata Locomotive and Burma Cell. So, Honorable Supreme Court said a mere easy entry of goods into a local area doesn't invite in tax liability unless perhaps that is for use, sale or consumption, sale or use and sell therein. Then the tax rate shall be 12% maximum of the purchase value of such goods. Where Section 3 doesn't speak of open market price, doesn't speak of the mechanism contemplated under 2J. So therefore, any rules or any mechanism, subordinate legislation to assist, aid and assist the charging provision must be in consonance with the charging provision. It cannot traverse beyond. That will be humble submission, Milos. And alongside these three, let my lords also, Milos, kindly see entry 52 of the 7th schedule of the Constitution, Milos. List appears entry 52, list to 7th schedule.
Yes.
Minus. Yes. Taxes on the entry of goods into a local area for consumption, use, or sale therein. Yes, this is the source legislative field, Milos.
Yes.
On which state has the power, Milos, to make legislation. Now, taking into account the language of entry 52 and the charging provision of section 3(1), read with 2 because 2 is the person identified with us. It is to say whether this provision under 2J contemplating levy of tax on open market price on sale price can actually be permissible. Now, next I will take my lord's attention to the object and results of the enactment laws. My lords may kindly see from the book as it talks at the very beginning. Yes. Sorry, statement of objects and reasons, my lords. Okay. My lords, what?
Yes.
Yes. At the beginning, my lords will kindly see. Police Act 11 of 99, an act to provide for the levy and collection of tax on the entry of goods into local areas of the state of Orissa for consumption, use or sale therein, and matters incidental thereto and connected therewith. Now, you also kindly see at the footnote, statement of objects and reasons, Milos. At the footnote, it is there. The bill seeks to provide.
Yes.
The bill seeks to provide for the levy of a tax on entry of goods into a local area for consumption, use or sale therein, as enjoined under entry 52 of list 2 of the 7th schedule to the Constitution of India. The tax is proposed to be levied on every dealer in scheduled goods or any person who brings or causes to be brought into a local area the scheduled goods at such rates as will be prescribed by government, not exceeding 12% of the purchase value of such goods. The bill also seeks to make provisions inter alia for furnishing of periodical returns, appointment of taxing authorities, assessments, appeal, revision, maintenance of accounts, completion of offences, refund, recovery, assignment of proceeds, including other enforcement provisions, and the provisions to empower the state government to make rules for carrying out the purposes of the bill after enactment. Then 3. The bill further seeks for abolition of octroi duty levied and collected under the Orissa Municipal Act 1950 by repealing clause KK of subsection 1 of section 131. Thereof, the bill seeks to achieve the above objective. Plus, meaning thereby, prior to coming into operation of Orissa Entity Tax Act 1999, plus octroi was levied by municipalities laws by virtue of provision section 139(1) KK of the Orissa Municipal Act laws. But the source of entry remains the same. Octroi 52, this one of entity tax also 52 laws. And it also again object refers to entry 50 because it can't otherwise traverse also. Straight cannot. Now, let's I have to address my lords on some propositions in nutshell. I have made precisely some propositions on which I will proceed before lordship.
Give us a note or we have to take
Yes, these are short propositions. I will give at the end, I will give a short note. But the first proposal of my lords is, with my lord's kind permission, local area, which I have already taken my lord's certain definition. Yeah.
You have exhaustively dealt with.
Yes. No, I am not once again taking my lords. I am only advancing proposition, my lords. So, as per the definition of local area and entry of goods, and the expressions used in section 3, that is on the entry of or on entry of, plus when that is read alongside section 3.1 and provisions of section 3.2, as well as proviso and explanation, this points out, plus, that the liability to pay entry tax is on the first entry into a local area, and value of goods at the time of such first entry shall be the measure of tax for the purpose of taxation. It cannot be understood to mean that entry of goods into a local area where the assessee resides or carries on business shall be the measure of tax. To put it other way, as I said, local area, every inch of land in the state either way constitutes local area. Because once goods come from outside the country, whether by air or by vessel from outside, once it reaches the landmass of the country, that is judgment of the Honorable Appellate G.K. Gokhal's case, once it crosses the corresponding frontier and touches the landmass, that is entry of goods into any state, anywhere in the country belongs.
Into the local area.
Yes, and so for our state is concerned, means be it Paradip or Vimso by air or water or any other minor ports, if it touches the landmass, there is entry of goods. Now, Honorable Apex Court has also made it clear that all imports are now liable to tax. Even if for a year together we have been availing exemption by virtue of this judgment of Kerala High Court. So now every import is also taxable, coming under Anti-Tax Act. That is the only point here, of course. My humble submission is, be as it may, supposing goods have been coming by road transportation from Kolkata to Odisha. So when it crosses the boundary, after crossing West Bengal and touching the territory of Odisha millers, local area starts. And in process of movement of the vehicle from the border until the goods reach at a destination where the assessee belongs to, either has a manufacturing or trading unit or whatever, and he wants the goods to be unloaded, delivered. Because he might be crossing across several local areas. And every moment, at every local area that they are passing adds cost to the goods brought in. Now, question arises, Miros. So far as section, provision to section 3 is concerned, that prohibits multiple taxation. If the tax is paid by some person or any other person, because your Lordship have seen 3.2, not only the person who brings the goods, but any person to whom goods are delivered, or person who is entitled to the delivery, even if they are not the owner of the goods. Ownership is not material under anti-tax law. Even non-owner can also be liable to pay tax if he is entitled to or take delivery of the goods. Yes. So therefore, my lords, when the goods are coming from outside and passing through different local areas, adding to the cost of goods, my humble submission, the
main sine qua non is the entry.
Entry, correct. That is what Honorable Apex Court said. I to answer your question, yes. So therefore, what is paramount is entry of goods and vis-a-vis local area, of course. Then question arises to us about which local area? Whether first local area, second, third, because 10, 20 local areas he may be crossing in the process ultimately while giving delivery of goods. My humble submission is, once taxable event takes place on the first entry, liability ensues. Just to the best of my what I want to convey to my lords. Because so on the first of the entry local area, taxable event belongs to place. Liability ensues. I don't say resign from liability ensues. Now the question is whether first, second, third, or ultimate. That's the question, number one. My respectful submission also is that it is the first local area and the cost of goods, value of goods at the point of entry is the measure of taxation for the purpose of entry tax. This is the first proposal I am advancing for Lordship. And my submission, humble submission for Lordship, is in consonance with section 3.1. Section 3.2, definition of entry of goods, definition of local area, and entry 52. Yes, sir. That is what. Second proposition, which I want to arrange for seminars.
Yes.
Because I have gone through the counter affidavit filed by your friend. They have given a very detailed counter affidavit, which one may lose patience to cover because it's more than 60-70 pages. And of course, that is enlightened us. I have gone through. We have gone. So that says, on second proposition, they say that they have distinguished the source of acquiring goods. One is by purchase and other than purchase, for which we are equal seminars. So far as purchase is concerned, they say that it is supported by an invoice or bill millers. And invoice, according to them, is a document of titled goods. One becomes owner. So person in whose name goods are there in the as per the invoice is the owner. But so far as transfer invoice is concerned, that doesn't give it ownership. Anybody producing this entitlement to receive the goods. And the value mentioned in the transfer invoice are for the purpose of insurance claim, according to them, are a tentative price. It can be more or less. So therefore, that price is not sacrosanct for the purpose of taxation. That is what they have said.
But this Act provides that the price can also be gathered from the insurance also.
Correct. And not only that, because in many 90% cases, because the invoices, they are all statutory invoice. Suppose excise invoice, it's a statutory invoice. That is, in the statute, it contains the particulars. We can't have any interpolate or substitute that. Because we have to charge excise duty, we have to mention all relevant particulars. It's a statutory invoice. Custom is the same. So therefore, it is not that invoice is a document or that challan come invoice, excise challan come invoice. Those are statutory documents. In any case, that is the argument they have made. Stand they have taken counter of it. My humble submission for RCP belongs.
What is your second proposition?
Exactly, I am coming to that. My second proposition is belongs. So far as the anti-tax law is concept of anti-tax law is concerned, there is no distinction between purchases sourced from on the strength of invoice or purchases sourced other than by virtue of invoice, because the ownership has no role to play. One may not be owner, but one is liable to anti-tax. So if one is not liable to pay, one is liable to pay without being owner. So whether he is transferring invoice or same invoice, how does it matter at all? This doesn't matter at all. So that's what matters is, and they have said so in the context of 2J.
Yes.
They have said so in the context of 2J, which says that if the goods are up, you are purchasing on the strength of invoice, you are a gentleman, go, we are accepting, even if it may be containing a wrong figure, false figure, which are again subject to adjudication, but you are presumably you are correct. But once you are bringing or acquiring or obtaining this other purchase, then we will send you to tax you at the sale price, open market price. Now the question is, I am on this. If the goods are sourced otherwise than by a bill, by any other document, transfer or any other document for that matter, and ownership is not material for the purpose of anti-tax laws, how can there be discrimination? Keeping in Article 14, one will be taxed at the disclosed rate and other will be taxed at open market price, for which there is no even mechanism also. Therefore, entry 52, section 3, taken together, this leads us only to the only rule that it is the value of goods at the point of entry.
Yes.
Either you make rules under section 37 provides the power to make. You did not frame any rules for us. Because you did not bring a mechanism. Even if you got it didn't contain a mechanism. So therefore, you have to devise the mechanism by virtue of which you have to give mechanisms finding out or determining the value at the point of entry only. You can never go to any sale price, which is a X hypothesis. That price cannot be neither displayed nor received by anybody.
What the third point?
Perhaps third point. Third point is, perhaps section 3 clearly contains the expression purchase value. It doesn't speak of any other value, perhaps purchase value. Therefore, any other provision contrary to section 3 in particular section 2J here, providing measure of tax by a different provision to levy tax on scheduled goods of like kind or like quality. Well, also kind of bearing line expression very peculiar and very critical. It says that goods of like quality and like kind capable of being sold or capable of sold in open market will be the price. So therefore, when charging provision only speaks of purchase value, a definitional provision which you claim to be a measure of tax for the corporate taxation cannot
overshadow the charging provision.
Incorrect.
That's all.
And you can't have a market price or like quality like you can't have. That is my third proposition. And it's arguing to section 3.
There are more points to argue.
Apart from this, minors, yes. Now, the other one is the point number 4, provided to section 2J. If that will be considered as contended by the revenue bureaus as measure of tax, then the expression used like open market price in section 2J clearly transgresses entry 52. That is my proposition. Okay. And the outer verse. Then point number 5, rule 17, which I read for Osibulos.
Yes.
But that doesn't contain any mechanism. Even though section 37 confers powers of the legislature to make rules.
Yes.
And 37(1) is important because that clearly says for the administration of that, anything that is required to be legislated, state is given power to make appropriate rules. That has not been done. Otherwise, without doing so, Rule 17, which is a comprehensive provision nomenclature, you will also work in a very comprehensive nomenclature and doesn't provide anything regarding modality or this provision for making any calculation. I mean, measure of tax, nothing is there, no mechanism for measure of tax. And then next, the first case is decided against me by the assessing authority only on the ground of Volta's case judgment.
Okay.
I will take my lord's attention to the findings, only one line from the findings. He has dealt in third way, but lastly, the findings is the only one line. It starts from page 43 and the concerned relevant page, you will also be kindly turn to page 57. Page 56, I will also kindly start, page 56 of the brief.
Yes.
Yes. Because a case having some second paragraph, a case having same facts and law, the issue came for adjudication before the Honorable High Court of Karnataka in the case of Voltas Limited versus State of Karnataka, when section 2A8 of the Entry Tax Act of Karnataka, which is similar to 2J of the OIT Act, provides for determination of value of goods which enters the local area, otherwise done by your purchase and the tax is payable on the basis of said value. Entry tax that will be payable on the goods that enters the local area and the instance of person who is not purchasing the goods could only be on the basis of market value of such goods in local area. When the language employed in the section which provides for determination of the value of goods is clear and unambiguous and doesn't lead to any absurdity, it is not permissible for the court to interpret the said provision in any other manner. The court has to interpret the section as it reads. Then this is the only sentence findings you are going to see. In view of the High Court of Karnataka, the instant dealer has to pay entry tax on the market value of the goods inside the state of Odisha. So therefore, the entire findings, conclusion to levy entry tax on the market value of the goods is the judgment of Honorable Karnataka High Court in the case of Voltas Limited. Now, before I take my lord's attention, to the judgment of Voltas and other judgments, the provision of Karnataka, State of Karnataka Entry Tax Act is different. One. Number two, the judgment of Honorable Karnataka High Court in the case of Voltas can be said to be judgment in per curiam and has no binding effect on my lord's. Otherwise, that is also a judgment of the other High Court. It has only persuasive effect, and it cannot be have any binding effect. And thirdly, even though the Honorable Karnataka High Court,
Hopefully, there cannot be any thirdly.
minor. Even though the Honorable Karnataka High Court has reproduced in verbatim the conclusive part of the judgment of Hansa Corporation without any analysis or any reason, it says judgment of Honorable Sub not applicable. Honorable High Court says the judgment of Honorable Sub not applicable. That's only one line.
Okay. That's all.
But now judgment, okay, true judgments only, precisely I will submit yours.
That's you have given it. Just given the paragraphs also given in.
Just having brief or very precisely.
We have a problem. We have a matter fixed at 3. Then we have to resume after that matter. 3 p.m. also. No?
Keep it to a short date so that we will complete. Because I will take very.
No, that you have already covered.
This is also equally important.
Tomorrow is not possible. Then in Tuesday it will go.
Tomorrow you will also that matter is also fixed.
That is there. That is there. And moreover, tomorrow there is a reference also. Monday is possible.
Internal.
Monday, so Monday it will come at 2.
At 2 p.m. Minus. 2 p.m. third.
There is another matter at 2 o'clock.
At 2 p.m. There's another matter.
Just we take up the matter because we assured someone his address is online. That is why, because otherwise there will be dislocation. You'll take up the 2 p.m. fixed matter just immediately after that. Are you ready for that?
Yes.
Myself?
No.
Oh, sorry. 3 p.m. matter. Your Lordship is referring to the 3 p.m. matter?
Yeah.
Your Lordship, Chidambaram is already online matter, logged in for 3 p.m. matter.
Okay.
I believe my learned senior, Mr. Mishra, was about to.
Yes.
Mr. Mishra, today only time concluding your remarks.
Whether that tomorrow matter, whether tomorrow since reference is there, whether that can be taken a pre-launch.
Mr. Mishra, it has to be pre-lunch.
Your Lordship.
Because after 2 p.m. there is a single bench.
Your Lordship.
The other 2 p.m. matter will be taken up after this.
After this, if you get time. You have completed yesterday. Only just you will give the.
I'll give a brief account of it, yesterday's argument and complete.
You have completed just only because you said that I need.
I'll do it.
Wait, please.
Lord, item 28, your lordship said fixed, where I had already assisted my lords. The state had to respond. Lord, the state had to respond. I had already assisted my lords.
Yes.
Would your lordship be inclined to take up that matter today, or is a sponge and iron?
79. Yes, all.
79.
Just few more minutes. It is in the concluding part of one argument. Item number 79 is not there in item 74. 29. Yes, Mr. Mishra.
think Mr. Jain is looking for the other matters. Right.
Yes, my lord, item 29, I'm by VC. Am I audible, my lord?
Yes, but now we are not taking 29. After some time, we will take 29.
After 79 will be
79 is there is a little leftover yesterday, so they will complete that part. Yes.
My lord, only this, that I had assisted my lords to show we had a crystallized right and the state had to respond to our submissions. I had concluded. Very well. Great.
But I'm sorry if I do repeat one or two documents, but I'll be very precise and I'll conclude it, my lord. But if you also kindly appreciate,
yes,
the award doesn't suffer from patent lack of inherent jurisdiction. Question of interference doesn't arise. Normally, that is I have already indicated yesterday, my lord. It has been held over 3 years on bench of the Punjab State Power Corporation, my lord. 2020, 793. But to justify that, this case doesn't fall within the category for interference. One of the main criteria, Your Worship, asked me yesterday also, whether my enterprise comes beyond 5 crores, is within 5 crores. That is one of the main criteria for the purpose of appreciating whether it will come within the purview of the MSME Act. But my respective solution will be only twofold. One is that 2M is the definition chapter which tells or precisely indicates that an industrial undertaking can also be an enterprise. Therefore, I come up with the definition of that. Number 2, I have been granted a certificate by the competent authority of the state government, which has been approved by the central government as well. MSME Act and the Central Act is there, State Act is there, and State Act provides that I am entitled to the certificate on verification of records.
Yes.
That certificate has not been challenged. Well, that certificate holds good till now, and the same has been renewed from time to time, depending on the verification and inquiry conducted by the local authorities. Well, it's a committee constituted by the government that also makes an inquiry. The other point I wanted to bring your worship's notice is that the other side argues on the basis of the balance sheet of the company. Company means this Gupta Power Transport, but it has got different in the undertakings, enterprises. But Khorda unit, Uttarakhand unit, Chennai unit, 3. The balance sheet is filed together joining so far as the plant and machineries are concerned. Therefore, I'd like to read your 3 documents, nothing else, only 3 documents. So kindly look at page 86. This is the balance sheet of the company that we referred to.
Yes.
Annexure 7. Which they have filed, my lord.
Yes.
This is my document they had filed. Can you look at the heading, Schedule E fixed assets, schedule forming part of balance sheet and profit and loss account. But I think you have seen this document. Only serial number 2, kindly see. Land leasehold, plant and machinery. Plant and machinery refers to the end, if you also look at last but one line, one column, 6 crores 54 lakhs 70,000. But this comprises all the 3 industrial undertakings. There's the enterprises for it.
What Mr. Chidambaram on the day 1 argued, he says that those are to be clubbed together for purpose of getting the
exactly. Absolutely correct. I bowed on to your worship. If they wanted to indicate all the 3 to be clubbed together for the purpose of assessing whether I am a MSME unit or not. But my responsibility is that each one is independent.
That you argued yesterday.
No, what I say, independent.
You said the Khurda unit is independent.
The clubbing part was introduced for the first time in 2015 by a notification.
Yes.
That notification has been withdrawn in 2016. the central government in the MSC department, the Ministry of MSC department were conscious about this fact. Can you look at that notification ballot? No, before that, can you look at page 290? Just 1 second, ballot, page 290. You see, Malay Justice Ratho also pointed out this the Chartered Accountant's certificate. This is to certify that basis of books of accounts, financial statement, and other records produced to us by our verification that the investment in plant and machineries as per audited balance sheet 31/3/2011, 31/3/2012.
All right.
Page 290, got it? 290. 290,
yes.
290.
Annexure 26.
It's a part of the annexure.
Part of annexure 26, yes.
Yes, madam.
Annex to annexure 26.
290, madam.
Is.
Madam, got that document, madam? Yes. This speaks about of various units of Gupta power infrastructure. The 3 units and the 4 units are there. In Kasipur, Uttarakhand, there are 2. Unit 1, Unit 2, Khordha is 1. Then Bombay is Chennai, 1. We are concerned about Khordha with the investment in plant and machinery as per MC financial year 31/3/2011, 2.50. And 2012, it is 2.15.
Yes.
But all 3 combined together, if you actually looks at, is 6.54. And then 2012 it is 5.47, which is exactly the same figure as 86 and 87. Quite clever. But this is the individual units. But this, if you can look at the other government notification, 328. Us to clarify the position of clubbing ballot. So can we turn to page 329? It's 29 September 2015. Top right ballot. It says withdrawal of clarification issued relating to clubbing of investment of different enterprises under the same ownership. Under the same ownership, the matter regarding clubbing of various enterprises, whether located in the same district, and all various districts of the state or country under the same ownership have been examined by this office. The competent authority, after examining the issue in depth, has decided that the investment in plant and machinery equipment of all enterprises on the same ownership shall be clubbed together while assessing the status of MSME as per provisions of the MSME Act. This supersedes all earlier order and later clarification issued in this regard. This issue with approval of the Special Secretary, Development Commission MSME. Now, if you also turn to the next page, 330. That was 3/3/2016. This withdrawal of circular number 5/4/2015 dated 29/9/2015, the previous was of this office on clubbing of investment of various different enterprises on the same ownership regarding reference was given on the same, then it is to inform that the above referred circular has been withdrawn with immediate effect.
Excuse me.
This issue the approval of the Honorable Minister of Micro and Small and Medium Enterprises. It has been communicated to HON'BLE. Well, these two documents we find to show that on the same ownership, different enterprises, various enterprises are there. Each one is individual MSME. They wanted initially to club it. They decided not to club it, they have withdrawn. Therefore, I am one of the enterprises, Khordha unit, on the same ownership. But this was also in 2015, once again verified, checked up, and that also certificate has got it. That is also there on record. So my respective solution is that if I am coming as an enterprise, on the definition of 2N, and my 2N.
No, according to you, that the clubbing together is not innovative.
Not exactly.
It's most optional. That's come in the way that if you can also claim the status on the basis of one unit, though you may have the several units. I mean, enterprise.
One ownership, yes. Under one ownership, there may be several enterprises.
Exactly. That you can also claim the status on the basis of one unit.
Yes.
Am I correct?
Yes.
Point is well taken. So, okay. Thank you.
No, that's the point. And my total value is within 5 crores. The certificate pays 66.
That's so obvious. Either from the certificate or the calculation from the table. These are not taken together. Unit will be single and below the 5 crore limit.
Right, below 5 crores. So that is the first point with regard to the enterprise is concerned. So far I am concerned, Khordha unit is concerned. But the second point is with regard to procedural part. But your lordship, I have already indicated to your lordship that the procedure has been followed. Whether it's a correct procedure followed or fault, some more could have been done, and opportunity has been granted. They participate in the hearing. There may be 4 or 5 days of hearing. But there has been also taken note by the commission, the authority who have adjudicated the matter of the arbitrator, and also the honorable single judge. So my short point of respective solution will be, so 34 is there. Section 19 and 34 is there. This is not a patent invent like a jurisdiction for interference in Article 226. Clear. And the decisions, if you also kindly say, in those cases, nothing has been done. No hearing took place. No adjudication took place. That's why the Honorable Supreme Court condemned the matter, saying the procedure has to be followed. And interference was there. So the other decision I cited for Lordship yesterday in the last meeting, I just will bring your Lordship notice. That is Gujarat State Civil Supply Corporation.
Is which paragraph?
Sir, paragraph 25 or something, can you see? I'm not reading all the paragraphs, but lot of paragraphs are to be referred to here, like paragraph 3, 4, 5, 6, 7 to 8, 9, 10, 12 to 15.
So that the paragraphs get the factor.
Paragraph 25 words.
Yes.
এটা নে অলগা কালে ওটা দেখছিলে এটা তলে দিয়া আছে সবার তলে ছিল ଯୋଉଟା ଦରକାର ସେଟା ଦଉନାହାନ୍ତି ଦେଲେ କେତେ କେତେ ଏଇଟା ନୁହଁ ଏଇଟା ମୋର No, I'm looking for
Gujarat State Civil Supply Corporation 2022
ସେଟା ଥାଉ ସେଟା ନିଅନ୍ତୁ
Yesterday, did you give 2 copies?
Yes.
All right.
I gave 2 copies.
Everything, sir,
And also
we
take
cannot
copies of
to the brief. That is where it will get.
Yes, sir. Thus, the Arbitration Act 96 is general governance of law of arbitration and conciliation, whereas MSME Act 2006 governs specific nature of dispute arising between specific categories of persons to be resolved by following specific process through specific forum. Here we go. The MSME Act 2006 being a special law and Arbitration Act being a general law, the provisions of MSME Act would have preceded over the or prevail over the Arbitration Act. I am not reading any further below. Can you turn to paragraph 34, Malad? The issue that was decided on that decision, Malad, has been codified here. So number 1, Chapter 5 of MSME Act will override the provisions of Arbitration Act. Number 2, no party to a dispute with regard to any amount due under Section 17 of the MSME Act would be precluded from making a reference to micro small enterprises facilitation council through an independent arbitration agreement exists between the parties. Though an independent arbitration agreement exists between the parties, that will not stand in agreement. That is also one of the grounds on which the challenge before this honorable court. The Facilitation Council, which had initiated the counseling proceeding under Section 18(2), would be entitled to act as an arbitrator despite the bar contained in Section 80 of the Arbitration Act. 4. The proceeding for the Facilitation Council Institute Center acting as an arbitrator appointment tribunal under Section 18(3) would be governed by the Arbitration Act. The Facilitation Council, 5. The Facilitation Council Institute Center acting as an arbitral tribunal by virtue of Section 18(3) of the MSME Act would be competent to rule on its own jurisdiction as also the other issues in view of Section 16 of the Arbitration Act. A party who was not a supplier, as per the definition contained in Section 2(n) of the MSME Act, on the date of entering into contract cannot seek any benefit as a supplier under the MSME Act. If any registration was obtained subsequently, the same would have no effect prospectively and would apply to the supplier of goods and vendor service subsequent to the registration. In our case, our registration is 2008. The page 66 I have shown you also. And the transaction is 2009 to 13. And sir, it's a continuous process. Like payments are, the supplier was made, the payment has been made. It's a continuous process in a discharge of business transaction. But the question of limitation also doesn't arise here.
Yes.
So this is precisely the point where I wanted to convey before Lordship.
Yes. Would you like to respond?
Your Lordship, Mr. Chidambaram is
Lord, I'll be very, very brief, my Lord. I know the pressure on your Lordship's time. Your Lordships have given me enough. Lord, I'll be very brief. The first argument of my learned friend is that it's the unit which has to be classified as a micro, small, or medium enterprise. He produced 2 circulars, one prescribing something, the other withdrawing that something. I am not relying on those circular. The circulars are completely irrelevant. The circulars were issued in 2015 and withdrawn in 2015. We are talking about a period 2009 to 2013. So those circulars are completely irrelevant to our case. And your Lordships are certainly aware, and your Lordships have laid down, interpretation of a law is the function of a court. No officer can interpret it. Ultimately, it's your Lordships who have to interpret the law. Now, we have an act here, the MSMED Act. The rival contentions are, the Act contemplates classification of enterprises. An enterprise, for example, Malad, let's take an enterprise can be 2 things. this act covers goods and services. We are talking about goods. So there has to be industrial undertaking which produces goods. Now let's take, for example, a company like ITC. ITC produces cigarettes, produces various consumer goods in different locations. ITC is certain, each location, in one location, say it could have invested less than 5 crore. Does it become a small enterprise? The question, therefore, is what is the enterprise? Now, therefore, my submission is, one, your lordships have to interpret the act. Please read section 2N. I'm not repeating. Please read section 2N, read with section 7. Enterprise can either be a proprietorship, HUF, association of persons, cooperative society, partnership firm, company or undertaking. It is the enterprise which matters. It does not matter which unit is supplying the goods to me. I am not concerned. The second point is, I place the purchase orders on GPIL. Now, just kindly, all the purchase orders are attached. Invoices are raised by them. The purchase orders have been placed. The invoices have been raised by them. Invoices raised by GPIL. Purchase order is placed on GPIL. And the invoices are on page 75 to 145. So he raises an invoice from GPIL, whether he supplies from the Kurda unit or whether he supplies from some other unit or the Gumiripund unit, it's not my concern. I'm placing an order on GPIL. Therefore, Milord, my submission is, the first submission is, it is the enterprise as GPIL, and each unit cannot become a small enterprise or a micro enterprise. That is one. Milord, this is a completely a preliminary argument. Let's keep this argument out. Without prejudice to this argument and ignoring this argument, we'll assume his case is correct. Now, what happened in this case? The case is, there was a claim, there was a counter, there is a rejoinder. Now, the council holds 4 meetings, and those dates are given in the order, 4 meetings. At the 4th meeting, it passes a so-called award. It says a claim is so much, the whole claim is reproduced in a page, the whole counter is reproduced in a page, the whole rejoinder is reproduced in a page, spills over to the 4th page. And in the 4th page, your lordship will kindly see that order. This is not an award. This is not the procedure followed. And there are 2 judgments under this very act which concludes, and I will just invite your lordship's attention and conclude. Now, kindly have the award that has been passed. Page 216. How can this be classified as an award in the light of the 2 Supreme Court judgment, which is very clear? In 216, Annexure 20, kindly see, Milord, all this is, both parties were present. 217, both parties are present before the council in its 42nd sitting. 217. Yes. The petitioner submitted, middle of the page, 217.
Yes, got it.
The petitioner submitted before the council. The case is pending. Initiating the discussion, the advocate on behalf of the OP, that is my client, submitted before the council that the management of Gupta Power Infrastructure Limited, the petitioner, the claimant, is in touch with the management of JSW to have an amicable settlement and prayed 7 days' time to intimate its outcome to the council. In response to it, the representative of the petitioner declined to have such information. What he means is, he said, I have no information. As a result, the council may go ahead towards a disposal. The council went through the deliberation made by both the parties and directed the OP to have amicable settlement with the petitioner and inform its outcome to the council in writing within 7 days from today. The next sentence is crucial, Milord. If no communication is received from the opposite party within the stipulated period, award will be given for payment of the outstanding dues. But this is a completely premeditated mind. He's not here deciding the dispute. I'm giving you 7 days to report a settlement. If there is no settlement, I'm going to pass an award. This is certainly neither conciliation nor arbitration. And over the page, the counter is extracted at page 218. The rejoinder is extracted at page 219. Over the page, it continues in paragraph 9. And these are the 10 lines of the so-called award. Both the parties were present before the council in its 45th sitting of MSMFC on 28/6. Petitioner stated case was pending since 24/4. OP stated petitioner was not an SSI unit. That's my contention. The council examined the PMT registration certificate and concluded that the unit is an SSI unit. Obviously, it refers to the Purda unit. Unit is an SSI unit, not the enterprise. Further, the council observed that this case was heard on A date, B date, C date. This is the fourth hearing. The council had directed the OP on 21 at its 42nd sitting to make an amicable settlement in writing within 7 days. But the conciliation was failed. There was no conciliation. It is only an amicable settlement between the two parties directly talking to each other. In the meantime, OP filed affidavit on 27/1 and 21/4. Petitioner filed its counter on 28/6, and we are on 28/6. He receives my counter. Council went through the relevant documents filed by the OP on 27/1 and 21/4, and the counter of the petitioner on 28/6, and decided to pass an award on the same day. And all of them have signed on 28/6. So where is the arbitration? Where is the procedure of the Arbitration Act followed? Well, this submission is completely independent of the first submission, that it's your lordship who have to interpret section 2N and section 7. Well, in order to save time, as I said, your lordship, just give me 3 more minutes. I've prepared a written submission, and I'll ask my learned friend, Mr. Mohanty, to hand it over to your lordship.
You're frozen temporarily.
No.
I'm just taking another 3 minutes and just pointing out what is the written submission.
Yes.
Mr. Mohanty, please hand over to my lords. Please give other side a copy.
Yes.
Well, I'll take.
We will also file.
Exactly.
We'll file it by Monday. We'll file one by Monday.
By Monday?
Monday.
I have no objection. Yeah, let him take time to file. Now, paragraph 2, I'm pointing out, purchase order were placed on GPIL and invoices were raised by GPIL. Then I've given the investment in the enterprise. Now, the learned single judge says, I did not challenge the certificate. I'm not required to challenge the certificate. I'm not questioning the validity of the certificate. I'm only saying Kudda unit is not the enterprise. It's one unit of a larger enterprise called GPIL.
That is we have already noted.
Yes, I'm just pointing it out. Now, on paragraph 5 onwards, I'm saying there are 4 exceptions to alternative remedy. Wordful operation. I come under 2 of the 4 exceptions. I've extracted the 4 exceptions. I come under two exceptions, namely violation of principles of natural justice and the proceedings before the council was wholly without jurisdiction. Those 2 contentions.
Yes.
Then limitation was raised. Limitation applies Silpi industry. I did not hear my learned friend make any admission on limitation. Any claim prior to 24/4/2011 would be barred by limitation. This is directly covered by Silpi Industries. There's 2021 SEC online. And the last point is in paragraph 7. My learned friend keeps on saying, I cannot file a writ petition. Let's go to section 34. both the judgments before the Supreme Court, Jharkhand Urja and Vijeta Constructions, were writ petitions. They were against the award. The objection was raised under Section 34. The objection was rejected by both judgments. They say you have to follow the procedure for conciliation. You have to follow the procedure for arbitration. Otherwise, it's a nullity. That is the language used by Justice Indira Banerjee. It's a nullity, and we will interfere in the writ petition, and the writ petition was allowed. Those are the two cases in paragraph 7. Now, paragraph 8, Your Lordship will see, I point out that on 28(6), there was no hearing at all. There was no hearing at all. And in paragraph 10, I'm submitting, jurisdictional issues were not decided. Statutory procedure was violated. Principles of natural justice were grossly violated. And the award contains no reasons whatsoever. In fact, he is premeditated in the previous hearing. If you don't come back in 7 days, I'm going to pass an award. Therefore, my lord, my submission is that this award, this so-called award must be quashed, and the learned orders of the learned single judge may be set aside, and your lordship may pass such other relief as your lordship please. My lord, this is squarely covered by the two judgments. Writ petition, Section 34 argument was rejected. Writ petition was allowed. Those are my submissions. I'm grateful your lordship allowed me to file the written submission.
But I have my reply itself will cover everything. I don't want to repeat it. All the only thing is I'll give a written note by Monday. I'll give a note.
Deeply obliged. Deeply obliged.
Thank you.
Deeply obliged. Deeply obliged.
Hearing is complete.
Who's appearing, Mr. Mishra? Who's appearing with you?
Amit.
Have you filed your wakalatnama?
Yes, we have filed. Yes, we have filed. Is it we have filed. No, writ appeal, we are appealing. So that if appeal is
Yes, nothing about writ appeal, yes.
Acha, we'll file one thing. Subsequent file.
While the Bhugalatnama right now is possible.
We have just handed over appearance sheet, just for your lordship convenience. We've just handed it over. Just for your lordship convenience.
Here appear also not put in check for file.
Because your name doesn't appear in the cause list, I just noticed.
We'll check up and still filing will help us.
Okay.
No, file today. Extremely sorry, my lord. Very sorry, my lord. We'll do it back tomorrow. Someone will file. No, the power has to be obtained with signature.
How you are arguing without the...
Well, there in the appeal, from the read also, we are continuing. Read application.
We'll wait. I do not know the practice of the High Court. Usually in read appeal, fresh Bhugalatnama is filed.
Will do. Normally, the same person carries forward.
Oh, it's understood.
By tomorrow, we'll do it. My apologies for that. Normally, according to some other council appears, you will appear.
No, that's actually depends on the nature of the Bhugalatnama executed by the client.
I understand, yes.
Right. Call of the other matter.
This is regarding grant of a mining lease.
Lord, I had already assisted my lords. I had already assisted my lords, my lord, on the last day and concluded my arguments, essentially showing that we had a crystallized accrued right which had been saved. So I had assisted my lords fully on the last occasion. My respondent had to, my lord, assist my lords.
Yes. So let me tell you, lordship, briefly what is the case. The petitioner, on 20th of October 1991, my lords, applied for a grant of mining lease.
Yes.
And it is his case that pursuant to an amendment made in 2015, you lordship may not note anything, I will give a list of it.
All right.
In 2015, the act was amended, and a section called Section 10A2, 10A was
inserted under the MMDR. Why 15 amendment is important? The 2015 amendment, relying on the principles enshrined under Article 39B, said that all mining leases have to be granted by auction. The objective was, it will be a more transparent method, and I will show that to your Lordship. And the state, which is the custodian of these minerals on behalf of the citizens, will get the bid price. However, they made certain exceptions. One exception was that if you have prospected an area, and I'll tell you actually what is prospecting, as a virgin area, somebody has spent money and time on being granted a prospecting license, he has done prospecting and find out this area contains X amount of reserves, then he will have a preferential right under the old act also. The old act said that if there is a prospecting license holder who has satisfactorily prospected the license, the area, he will get a preference over all others. So that was preserved. Under the 2015 amendment also, that was preserved. What was also preserved is that in the event the state makes a recommendation and the government of India has granted an approval, prior approval under section 5, the scheme is like this. The recommendation and approval both are statutory. Section 11 of the Act says what are the parameters and how you will consider an application for grant. And section 5 says that based on your recommendation, the government of India will grant a prior approval. So 10A2, so 10A2B is the prospecting rights holders application is saved. And here it says that if there is an approval and you have fulfilled those terms and conditions of the approval within 2 years from 2015, so it will end sometimes in January 2017, then also you will be considered for grant. Well, in 2021, the Act was further amended and the provision called D was inserted. 10A to D. I will give everything. Well, now we have only 10 minutes time, so I'm just giving you Lordship's overall picture of that. So 10A D said, 10A to D, that if the process has not been completed, because 10A2 says 2 years you have to complete. If it has not been completed, then all applications become infructuous, ineligible. The objective was, Millets, and I will show you Lordship from the 2021 or the statement on regions. They said that, look, the government of India as a matter of policy wants everything to be auctioned. We had given a leeway for some time for some people who had some kind of a right and interest. But if that has not fructified in any right, that goes. I have several submissions, but the easiest submission for today is this. It is the case of the state government that even 10A2C was not complied with the petition. Namely, he did not have the requisite clearances to be granted a lease, even on the date of amendment. So what was protected? You have an approval, you get all the clearances, and then within 2 years, if you get, you will get a lease. Now, why I say they don't have a clearances? Because they have actually have a clearance. Why I say so, my lords? Under the scheme of the Act and the rules, under section 5(2)(b), every applicant must have an approved mining plan for grant of mining lease. Now, what was told to your Lordship is that here is the mining plan we have. So, therefore, we have complied with 5(2)(b). It is my case, Lord, and I'll make it good, that the recommendation was made for a captive lease. The government of India has not given a captive clause. That is what we were troubling with your Lordships on the last time. Yes. The mining plan itself says, and I'll show that to your Lordships in a minute, Millets. The mining plan, which is at page your lordship may take it from me that mining plan is one of the documents, and I will show several. If you, my lords, kindly turn to page 87 of the brief minutes. My lords, at page 87. Just one document, nothing more than this. Mining plan is one of the primary documents for getting a mining lease. And if my lords kindly turns to page 87, is the mining plan of 24th of March 2005. My lords have it?
Yes.
Kindly now turn to minutes, page 89. And let us see whether this is a mining plan to grant you a lease minus a captive clause. It is very clear. The approval of mining plan is subject to compliance of the terms and conditions stipulated in item number so and so and 2 of the state government, Bhubaneswar, dated 27/9/2004, before execution of the lease. Kindly note, minutes. Before execution of the lease. So the mining plan says that you have to comply with ABC before you want to execute a lease. Let us see what is ABC. Kindly come to page 52. If my lords kindly turns to page 52, minutes. This is 27/9/2004. My lords have it, minutes?
Yes.
And let us see what were the conditions precedent in the mining plan which one had to comply, minutes. At 89, it said compliance of the terms and conditions stipulated in item number 12 to 17 and 2 of the state government letter. Now, what was this? Let us start with 2. 2 says the conditions stipulated in para so and so are subject to approval of the government of India under Rule 27(3) of the Mineral Concession 1960. So, therefore, your mining plan itself was subject to the condition.
You are reading from page 52.
55 minutes.
Sorry.
I am so sorry. I am so sorry. It starts at 52.
All right.
I am extremely sorry. 52 is 27/9/2004. My lords have it. Page 52.
27/9/4.
Yes. And that was referred to in the mining plan approval showing ships. Now let us see page 54. Kindly see page 54 minutes.
Yes.
It said, it referred to the conditions specified.
What is the problem? 54 something, it starts with a table.
Yes, yes. Milord, one second. Milord, if I go back to the mining plan at page 89, it said the approval of mining plan is subject to compliance of the terms and conditions as stipulated while item number so and so to so and 2 of the state government letter dated so and so. Milord, am I clear? And just one more, before execution of the lease deed. So this mining plan is saying before the lease deed executed, you have to do this. So what does those mean? If your lordship sees, the first one is at page 53.
Yes.
Which is Roman 12. My lords have it?
That is part of Annexure 4.
I am grateful to your lordships. So what it says is the assignment is subject to the condition that the company shall undertake expansion of the existing sponge iron plant at Porasmanga and proposed Bamla project within the scheduled time. So what the mining plan is saying, if you only do it before the lease is executed, this mining plan is valid. And it goes on like this. And if your lordship sees at page 55, paragraph 2, the conditions stipulated in para so and so are subject to the approval of the government of India under Rule 27(3) of the Mineral Concession Rules. So what it is saying is, I am approving your mining plan. It is subject to you getting a Rule 27(3) approval from the government of India. So my submission to your lordship is, my lords, leave aside my all other points which I will come to in course of time. There was no compliance of 10A2C, neither on 12th of January 2015, not 2 years thereafter, because the petitioner then has to show your lordships a mining plan which is hedged, not hedged with these conditions. Now, am I clear, milords?
Yes, yes.
And what is this mining plan? if my lords say kindly please, my lords, to see section 5 of the MMDR Act. My lords have section 5 of the MMDR Act 1957. Yes. My Lord Justice Ratho has it, lords. And there is a subsection 2, and there is one small b thereafter.
Yes, there is a mining plan duly.
There is a mining plan with 2. No mining shall be granted by the state government. So there is an injunction. No mining plan shall be granted by the state government unless it is satisfied. B. There is a mining plan duly approved by the central government or by the state government in respect of the categories of mines as may be specified by the central government for the development of mineral deposits in the area concerned. So therefore, the precondition for grant of a mining lease is that you must have a mining plan. And as I showed to your lordships at page 89, the mining plan on which they are relying upon is not for a merchant mine, but precisely for a captive mine, in as much as they say that before you enter into a lease deed, you get a compliance under 27. Not forget about anything else. Let us take their case on face value. Because if your lordship sees 10 at 2C, kindly sees 10 at 2C for a second, minutes. My lords have 10 at 2C. Should be at page 21 if you are holding the same book.
You're referring to 10A?
2C. Because that is their case. Their case is based on 10A 2C.
All right.
Kindly see, where the central government has communicated previous approval as required under subsection 1 of section 5, which I am contesting. Let us forget that also. For grant of a mining lease, or if a letter of intent by whatever name called has been issued by the state government to grant a mining lease before commencement of the MMDR Act 2015, the mining lease shall be granted subject to, my lords have that, my lords?
Yes.
Subject to fulfillment of the conditions of the previous approval or letter of intent within a period of 2 years from the date of commencement. Why it says 2 years? Because these are transitory provisions. We have decided to auction. We are giving you 2 years to get all your permissions. And your lordships are 5(2)(b). It is mandatory on behalf of a lessee to get a mining plan approved before it will get a lease. And the mining plan on which reliance is placed upon, that mining plan makes it as a condition that before you execute a lease deed, you must get ABC. And what happens, kindly see D. In cases where a right to obtain license or lease has lapsed, under clauses B and C, in my submission, C will lapse on 15/1/2017. That is 2 years from the amendment. Now, am I clear about the Act comes on 20th of January 15.
Yes.
It gives you a 2-year window. That window expires in 2017. Until now, you don't have a mining plan for granting you a lease, which is not captive. But I'll develop my arguments on the next date. Would your lordships consider 31st minutes? Or any other date as convenient to your lordships?
Mr. Jain is available in the street.
Mr. Jain was here.
So here is the
Mr. Mishra is there.
So it can be on 31st, I think 31st is.
Whatever date is convenient to your lordships.
Already next.
Fair enough.
Well,
let it be at 2 p.m.
31st को अन्य के साथ बुझान दो कोटा
So
First is Friday. Fourth.
Fourth is convenient to all of you.
Yeah, fourth is convenient.
All right.
Fourth is already
2 p.m. 4th of September, 2 p.m.
Lordship, item 57.
that interim order is there, so
Yes, no difficulty.
Order is first.
Item 57 is a part hard matter. Lordship, it is convenient for 29th Lordship 2 p.m. kindly.
2 p.m. is not possible. 2 p.m. is
Otherwise 30th Lordship. Because already it is covered Lordships. Already it is covered.
They do not agree with these covers.
The Lordships are another bench.
That is right. 30th, it will be taken up.
30th.
That's the matter with 2, huh?
30th.
You mention of the day.
57. 30th 2 p.m.
May I please you? Will it be at 2 p.m?
PIL matter 84 serial. PIL matters, my lord, that is the foot over bridge, construction of foot over bridge at Satrapur, my lord. It seems pending, my lords, 1800 to 92 today, my lord.
1892.
1890, the Chhatrapur station was made there. Station. People are suffering. So many persons to kill, my lord. Very urgent matter, my lord.
3 years.
84 serial may be taken any day. My lord's convenience.
Let us try on 4th.
84, right?
4th of September.
My lord.
8, I think 89.
84 serial.
84.
Milord, your lordships will have our matter on 4/9.
Your matter is
Yes, 4th.
2 p.m. Milord.
Mr. Joel, perhaps you have completed your submission.
Yes, I had for the petitioner completed, Milord, and I only have to rejoin.
All right, just on the next date, you'll give the short rejoinder so that we can complete hearing. Okay.
Very well.
My lord, that is 85.
Oh, 85. 4th of, no? 4th September 2020.